The following program is recorded with a 5-second delay. In the event of something truly horrific happening, the host has 5 seconds to calmly interrupt the flow of the stream and prevent the content from reaching your sensitive eyes and ears. Alas, the host has absolutely no clue whatsoever which buttons need pressing to abruptly halt a stream, so he will likely spend those precious moments screaming, "Oh my God, no, how could this have happened? Holy hell, oh my God, no, 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 why didn't I figure out how to fix? I knew this would happen, oh my God, I suck, damn it, damn it, damn it."
Good evening, everybody. Welcome to the following program. I'm your host, Joe Neeran, a.k.a. Good Lawgic, and I have a special surprise for y'all. I didn't even tell anyone. It's not in the description. I didn't mention it on X. I didn't mention it anywhere. But for tonight's discussion, which I think is a very important discussion about our judicial process, I have the king of reviewing judicial processes and assessing them, who volunteered to join me tonight, a very old friend of the show, and I'm so pleased to bring him on in here, the guru of appeals, and that is, of course, my friend Steve Gosney. How are you, my brother?
Guru for appeals for a few more days. That's correct. How are you?
They even knew. They knew where I was going. They're like, as soon as he said, like, yeah, they all knew. They all knew.
Yes.
So there you go. There you go. It's been way too long. So,
I know. I really miss you. I will say that I think of all the fellows on YouTube, we have the best chemistry, and I just love being on with you because it's just like the time flies by, and I know tonight will be the same. So I'm looking for this is an exciting law day for us law nerds, yes, especially for us like judicial error people like me. And I'm like, ooh, this is great teaching moment.
This is a great teaching moment because Judge Glanville decided, I'm going to just give you all the moments you want, guys. I'm going to give you all the moments you want.
Oh, anyway, crammed into one little condensed pustule.
So we need to start by just enlightening those of you who are unfamiliar with the background of this case. So there's this gang, which is known as YSL, which apparently is like a rapper who is closely associated with it. It's called Young Thug, amongst together with I think 5 other associates, have been indicted with RICO charges that include murder, attempted murder, distribution, basically the sort of things you would expect in a proper RICO charge, as opposed to the other one that's presently in Fulton County, at least for the moment. So in this context, there's 6 different defendants, and today we saw quite an outburst relating to the testimony of one Kenneth Copeland. So I don't know how much of the backstory you've seen so far.
Not much, but my son is familiar with this rapper, so he's clued in. I'm not clued into rappers at all. Right. But I will just, as an editorial comment, this is day 88 of a trial that's not even half. I mean, the end is nowhere in sight. Now, I will just say, as a matter of prosecutorial discipline, to have that long a trial is an absurdity. The job of the prosecutor is to present their case cleanly and directly and efficiently to the jury, to get the jury, the facts to the jury so they can decide. I don't know what they're doing for this kind of time. I haven't been following the trial, but to me, there's a problem with the prosecutor's office and there's a problem with the judge for allowing this type of abuse of trial. Now, it's a death, or maybe there's a death case, but they need to break up the defendants, go after one at a time. They shouldn't be trying them as a mob. I don't know what they're thinking, but they're creating a situation that almost no judge can keep a handle on this. So that's all led up to what we're going to be seeing tonight.
Yeah, well, and that's well said. And think if you're a juror on this case, you're 88 days of testimony into this trial, which they're anticipating will not be finished in 2024. I mean,
crazy.
Just imagine. And this is already the longest trial in Georgia history, longest criminal trial in Georgian history, and it seems as if it's not even halfway done. And today we may have seen grounds for a mistrial, which, oh my God, can you?
I don't think it's grounds. I think it's, to me, a mistrial needs to be granted at this point. But we don't want to show our cards too soon.
We don't want to show them too soon. Let me just get to a couple of super chats real fast. Welcome to the file. I'm not going to be doing extended following stuff tonight. All right. I'm just giving you a head stuff because there's a lot. I got a lot of ground to cover tonight, and I'm already expecting this is going to be like a 2.5 hour show. So we're not going to. Yeah, if you do it, anyone who donates or stuff like that, I will be thankful. I am pushing hard to try to get to 100,000. Pushing really hard. What's my count at right now? Let me take a quick look. Let me.
Subscribe to Joe of Good Logic. He's all close to the 100,000 mark. We're going to party.
Right now, I'm actually at 98,450 exactly. That's where.
Whoa.
See, Lady Logic didn't know how close I was. She didn't know how close I was. Yeah, I'm at 98,450 right now. She just said, "Whoa." Yeah, there you go. 98,450, and well, it's getting closer. We're getting closer. So whether you're on YouTube or on Rumble, if you can hit like and subscribe, I would be most obliged to you. And if you want to, if you're in the gifting mood, or if you're going to, join up here, I really appreciate it. But like I said, we have a lot of ground to cover tonight, so I don't expect to be going through extended stuff on that. With that, and it's all for nothing element. I love this for Fani. Yeah, Fani's prosecutorial team. They really set this ball in motion, both with the nature of the charges, right? I mean, like where they're charging.
They should break it up, simplify, edit your witnesses, be direct. It's the job of the defense to confuse things, not the prosecutors.
Yeah. How the heck are you supposed to remember something that testimony from 4 months earlier? It's astonishing. Yeah, it's gonna be like a year earlier. Family needs to get prosecutors in check, and if the source for steal is an employee of the court, aren't they technically covered by whistleblower protection laws? Probably.
I don't know. I'm not sure about that.
To establish that they're a whistleblower, there's usually procedure for whistleblowers. So I don't that you have to follow. You don't just go running to the other side and tell them. So I don't know that would actually.
Well, you know what you ask your appellate attorney. He says, "I'll get back to you in 3 days."
Great to have Steve, but subs 100K. I don't know yet. Where the axes go, guys. Two-Tone Steve and the Railco is my fictional band name for you.
Yes, well, I'm moving to Miami. I am going to join the Miami State Attorney's Office.
Wow.
And I'll be hopefully training prosecutors not to do these things. So I'm auditioning for my new job to train the young prosecutors. They hire 80 prosecutors a year, and I'll be helping out their training division as well as their legal advisor division. So I'm very excited. I've met with the entire leadership team, and they seem to be of my mindset. And I just can't wait. So I'm moving into Miami, starting my new job on the 26th of this month.
Wow. Congratulations. That's awesome. You go, guys. That's really fantastic. All right. So with that, let's get into, I want to start by introducing you all to Kenneth Copeland. Kenneth Copeland is an associate who's friends with these folks here. And he took the stand. I think he was called to the stand a few days back, maybe on Friday. And today, when he was on the stand, this is him trying to identify one of the defendants. And you have to see this guy. I shared a little clip of this with Steve, but this guy is a piece of work. Because
you got to set it up, though, because who is this guy? The state wants him to testify against the RICOs, right?
Mm-hmm.
And he doesn't want to testify against RICOs. So the procedure is they can grant him immunity and say, now we are, because he says, I take the Fifth. They say, well, we will not prosecute you under that Fifth Amendment. We won't use that stuff. So now we can order you to testify, and granting immunity. He says, I'm still not testifying. And so that's kind of where they left it. So he went back to jail under contempt because he wasn't going to cooperate, even when the judge told him to. And that lays out the situation we're confronted with tonight.
And there actually was some heat between Brian Steele and the judge regarding him pleading the fifth, because he's like, you knew the prosecutor knew he was going to plead the fifth and put him up there so that he would plead the fifth, and he had problems with that. And then they had this whole meeting this morning, which is going to come to the heart of this whole thing, the next parte meeting. But I just want you all to see. I want you to see this guy on the stand. It's only 3 minutes of him testifying, and he is just he's amazing. This might be my favorite witness of all time.
First, do you know someone by the name of Shannon Stillwell?
So Shannon Stillwell, just to let you all know, is a co-defendant of Young Thug, and so he's obviously sitting at the defense table over there, and so now he's being asked to identify the defendant.
Right, it's this guy. I'm anticipating. You gave me a little tease. I can't wait. Go ahead, lay it on me, baby.
So wait, what's his nickname? Do you know somebody named Shannon Stillwell? So Stillwell is charged with murder, attempted murder, and all sorts of terrible acts. I'm not saying he's committed them. Who knows? But yeah, so those are amongst the charges he's been hit with.
SB or Shannon. Or Shannon Jackson. Shannon Stillwell or Shannon Jackson, same person.
Yeah.
Okay. How long have you known Shannon?
We went to school together.
Do you remember which school?
I know one of them.
It was one of them. Okay. Was it elementary or middle?
Might be elementary or middle, one of them.
Okay. And I know I just said his nickname is SB. Is that what you call him?
That's what I call who?
Shannon.
No.
Okay. What do you call Shannon?
I call him Shannon.
And do you see Shannon in the courtroom today?
Well, I got a vision problem.
Okay.
I can't see that far.
All right. So if you want to stand up and look around the courtroom,
I got a
and
vision
look
problem.
around the entire courtroom, tell me if you see
far.
Shannon in the courtroom today.
This is called a hostile witness.
You think? He's looking around. He's like,
You need to sit down.
Nah, I give him light head. I ain't had nothing to drink.
Okay, do you want some water?
You gonna give me a drink?
I'll get some water.
I don't drink water.
Well, I don't have nothing else for you.
I don't
But I
drink
will
water.
put some water up there for you.
Would you give me a sandwich too?
Yes.
What am I looking for?
Shannon.
What am I looking for? I love it. Who am I looking for? I don't remember who I'm looking for.
I think I see him.
Okay. When you say you think, you can have a seat. When you say you think you see him, what do you think he's wearing?
Look like he wearing gray over there.
So who are you pointing to over there that's wearing gray?
I think the lady got red hair.
Okay, so you pointing to a lady and not Shannon?
No, the one behind her.
Okay, so you believe that the person behind the lady with the red hair is Shannon. Is that what you're saying today?
Well, it looked like.
Okay. Does anybody else over there look like Shannon?
Yeah.
Okay, who's the other person who looks like Shannon over there?
He's standing behind the bald head dude right there.
He's standing or he's sitting?
Sitting down, I guess.
Okay. What's his hairstyle?
Bald head.
So you're saying Shannon's the one with the bald head, or he's sitting
No, he's
behind
sitting
him?
behind the dude with the bald head. I think that's him.
Okay.
It's two people with dreads. I can't see. I just see dreads.
Okay. Let me just ask you this: is Shannon from Atlanta?
I don't know.
I
When
don't
you
know.
first met him, where did you meet him at? Was it in school?
Ooh.
Who? Oh my God. Yeah. So that's Kenneth Copeland. Who? Who are we talking about? Wait. Who am I looking for?
What was this?
Oh my God. That guy kills me. So that's Kenneth Copeland. That is Kenneth Copeland, who that was obviously being drilled by the prosecutor, trying to establish that he knew one of the defendants in this case. I'm not going to go through his entire testimony. His testimony isn't that long as 20 minutes, but there's enough ground that we need to cover here tonight that I'm not going to do that. Instead, I'm going to start with this right here, which is courtesy of some channel that I can't remember. And this is where we start seeing an outburst here, where there's an issue that defense counsel Brian Steele has with events that happened earlier this morning. And we're going to break this down together, you and me.
Yes,
and we're going to look at the law that they cite also, because they start throwing out law, and it's important to actually, they're familiar with the law, or presumably familiar with the law. Most of us are not, unless we actually look it up. So let's check this out.
I think this is Mr. Steele. I think his first name is Balls of.
Yeah. Oh my God. This guy, he has brass cojones. He does. You're right.
This is a defense attorney hero right here.
Yeah, he really is. And well, we'll get into it.
Sorry, I have a motion that I need to make outside the presence of Mr. Copeland.
All right, you can make it right now. Is he out?
Let me know when you get down to
Where is Mr. Copeland out?
No, he's upstairs.
Okay, good. All right.
Yeah, come on down. Don't come in the court. Come and get you back. All right.
Thank you.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any?
The phrase ex parte is a Latin phrase, which means like with only one party. Now, before we get any further, we should talk a little bit about the context of ex parte hearings and how they work in general before we zero in here. Are you familiar with situations where sometimes counsel, what situations in criminal cases? Because I deal exclusively with civil.
Sure.
So in criminal case context, are you familiar with scenarios where one side will meet ex parte with the judge and typical bases for why that would happen?
Sure.
Ex parte means the other side's not there. In general, we like having both sides there. So if you can give examples of that, that'd be great.
Yeah, and it's just because it's ex parte doesn't mean that it's bad. Like that's not says ex parte is illegal or unconstitutional or anything else. However, it depends on very much on context. Okay, so here's an example in criminal law where an ex parte approach by the prosecutor to the judge would be appropriate without the presence of a defense or defense attorney. And that would be, say they were seeking a search warrant. All right, a search warrant that is under seal. And so they would get the search warrant. This prosecutor would go to the judge ask for a place to be searched, and the judge would sign it, and there'd be no defense attorney present. All right. So that would be an example of an ex parte approach and discussion. So you would
Right.
think, and anything under seal like that. And sometimes those things are embargoed for say 30 days when they do like buy walk operations. So the cops will do a numerous buy walks, and then they'll have numerous warrants signed by the judge, and they will have the warrants in hand. So they got those. They did the buy bust. They get the arrest warrants. The prosecutor signed by the judge. Everything's done. And then they go do pickups, because if they tell the defendants, hey, we're coming to get you, they might flee, right? So it defeats the purpose of the sweep. But those would be proper approaches.
Right.
What we're talking about here is something that I have never seen. And I've been doing criminal law since 2004. And I've been on defense side and prosecutor side, had thousands of cases, 500 appeals. I have never seen a judge communicate with a witness on the stand ex parte without the defense counsel present. That is so unprecedented. It's made my jaw drop.
And what's astonishing about it is he's not a witness who made a potential witness. He's a witness who's still under oath from prior testimony that he gave. And all of a sudden now the judge is having conversations with this witness without allowing the defense to be there. And he's going to cite and he cites some law here, which I'm not sure if he cited it yet, but let's go a little bit further here. Where he goes,
and it's interesting because now when the defense attorney comes up and says, I got a major problem here, and I'm going to put it on the record, which is his responsibility.
Sorry.
That's what he says.
Yeah, go on.
Oh,
sorry about that.
Yeah, and then the judge's response is, how did you find that out? Right.
Right.
Which
is weird. It's a weird response. I'm just going to drop the horn here on Bella Stella. God bless you. Thank you for the 10 Good Logic memberships. You are awesome as always. The queen. She's my queen of recruitment. So she is. She's amazing. Okay. So let's go a little further here before we actually start pulling up case law.
That.
Well, I'm disturbed too. And the reason
I'm asking you a question.
And
how did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me.
Not really the same.
It's also ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said.
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
Now, what do you think about his refusal to tell him how he got the information? What are your thoughts on that? Your first thoughts when you're seeing
my first thoughts is, well, the judge is in the wrong. He's arrogant. And he is attacking this person who's called him out. Now he feels like he's in the crosshairs, and he's right. But his response is because he's so used to defense attorneys kissing his butt in his courtroom,
right?
That it's like that. Well, this guy isn't. So I'm going to wield my power. I'm going to make you bow down and kiss my ring, and I'm going to put it back on you because you got to answer my questions because I'm the judge, right?
Mm-hmm.
Now, a good judge would be very cautious in this situation. All right. And they would back off, have a little bit of humility. And if any, well, I don't want to spoil what's coming up. Right. So let's go on a little further.
We'll go a little further here. I'm going to pull up that Scudder case that he's citing there. I just want to, God bless the king of recruitment. We heard from the queen. Now the king pops in here with another 5 Good Logic memberships. Welcome to the following. All you new members of the following. I appreciate each of you who were gifted these gratuities by both Bella Stella and Master Phillips. Would certainly have the courtesy of extending a thank you to them because they are amazing people. So Let's go a little further here.
You can have his. I have problems right now. and
Okay,
I'd like to
I know.
continue.
Look, I don't want to know about your problems. Okay,
What?
at this
What? You don't want to? Okay.
point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
A party,
yes.
a witness who was sworn in Friday. The court's telling. This is what I.
That's not a party. That's not a party. And good on Brian, right? To like identify the distinction immediately, because sometimes, yeah, you can understand why a party might have some personal issue which has to be discussed, and you know, perhaps it's inappropriate to discuss it in front of adverse counsel. You can understand that. How does that play with where are the scenarios where that happens with a witness in the middle of their testimony?
The witness can't even talk to their own attorney during their testimony. You know, if you have a witness on the stand, and I've had this happen because they want to say, can I talk to my defense lawyer? No, you answer the question. You're on your own.
Yeah. Yeah. So good on him to identify that distinction. And yeah, he has brass cojones here, because this is not an easy thing to do.
And he's right on the, and I've actually been kind of in this position, not quite this situation, with a very hostile judge and a very hostile prosecutor where I have to read very nasty stuff, calling out behaviors in the courtroom.
Mm-hmm.
But then, actually, I haven't called out a judge like this, but it's not a fun place to be.
It's not at all, especially because litigators are trained to show deference to the court. And he, for the most part, I thought his tone there got a little bit uptight. Like he's like, I'm not gonna. Like it's like, you know, and he refers to you as opposed to the court. But this is really nitpicking on what was really an exceptional job of laying out what his issue is. He's citing the case law. He's saying why he has an issue with this. And the judge seems to be deflecting into covering his own butt with respect to, you know, the fact that this ex parte thing happened. But let's just pause for a second here and just think this through. If the Office of Court Administration for the state of Georgia were to come in and on behalf of Judge Glanville here, because at least that's the way it works over here in New York, is that when a judge wouldn't argue their own stuff, the OCA comes in and argues for them. So what if some equivalent bar association thing comes in and argues on behalf of the judge? Could they not point out that, look, if that the judge here was looking to try and establish whether there was some sort of problem procedurally with what's going on, and that's why he had every right to try and drill Brian Steele as to what the source of this information was, what the source of the leak was, because clearly, if it's some clerk working in his office there, he needs to, you know, plug that leak up, because that person could be a potential leak to the media and other matters, or and other ways that could be prejudicial to potential litigants in front of him. So does he not have justification? Could one make the argument, at least, that he has some sort of justification to try to figure out exactly what the source of this leak was?
I would say no.
Okay.
I would say that the defense attorney is saying that we have been excluded from an ex parte communication between the judge and the prosecutor and a testifying witness. And we've been excluded. I want to put this on the record and bring this out and have a ruling and maybe a mistrial. And the judge then says, no, the issue is the disclosure. The issue is not the disclosure. You know, if that's a battle for another day. If there is obligations to disclose, the defense attorney has a right to be present. That guy is on the witness stand. So what if, for example, and this is what the defense fears, the state says, why don't you just cooperate with us and we'll let you out tomorrow. We'll give you a deal. Wink, wink, wink. And the judge is sitting there saying, yeah, go ahead. You need to listen to the prosecutor. Defense isn't there. Now, when he's up there testifying, they have to cross-examine him for his motives for now testifying and changing his story. And they don't have the information. They don't have the Brady material. This is Brady, but that could be Brady material. We don't know what happened.
And I'll tell you something. I think the key thing that you mentioned there, that to me is really key, is because I do think the judge has a right to ultimately learn that information.
But now he's inserting himself.
This is not the moment. This is not the moment for that.
he's now, this is a battle. These people are on trial for their lives. They're defending themselves.
Yeah.
This is the attorney. This is the game that's being played. Now he's inserting himself into it with his own little courtroom battles. He's now injecting his own little personal, problems into a trial where these people are on trial for their lives.
Right. And the way he conducted, and it doesn't really, whoever revealed it doesn't undo the fact that his action of conducting this ex parte meeting with a witness is improper. So even if there was impropriety as to how this information got to Brian Steele, okay, we can sort through that also. But right now, there's a motion pending in front of you that he just brought saying, hey, I need to know what happened here because I think that I might be entitled to a mistrial, and what happened here was wrong. Yeah, okay, he wants to plug up the leaks afterwards, figure out whether he's got some rogue clerk working for him who's, leaking stuff to the wrong parties or things like that. The judge has a right to ensure that his courtroom and the processes that operate there are not being scuttled or sabotaged by some rogue figure or some rogue agent within his own confines, or to see if there's someone else who's deserving of punishment because they spoke out of turn. Perhaps he assumes that it was Copeland himself who spoke to his friend and who's client of what's his face, and that Copeland has to be punished because he leaked that he was that he was involved in that ex parte.
But in what way is that communication confidential? How in what possible universe would communications between the prosecutor and a testifying witness during their testimony and the judge, why would that be confidential from the defense?
Oh, it shouldn't be. Listen, I'm not trying to give a pass here. I'm not trying to give a pass here to Judge Glanville. Okay.
But in order to say there's a leak, that would mean that there's an obligation for confidentiality.
Well, okay. Let's say he's not allowed to have this meeting. In fact, let's pull up the case law that was cited here. Before we even go further, I'm going to pull up the case law that was cited by Brian Steele, which this is the Scudder case that he cited, and in this case, it explains why it is that what he was doing here was in the wrong. And this is Scudder v. State's 2016 case. And if we scroll down here, that's the court in this case said that Scudder correctly asserts that a criminal defendant has the right to be present and to see and hear all critical parts of his trial, which, conversations between a judge and a witness would seem to be a critical part. This is a fundamental right and foundational aspect of due process of law. And it's a right that may be relinquished. However, if the defendant personally waives it in court, if counsel waives it at defendant's expressed direction, if counsel waives in open court while the defendant is present, or if counsel waives it and the defendant subsequently acquiesces to the waiver, that's the only way that you can get around that problem. Is there has to be a waiver. And one of the things that Brian Steele aptly did at the start of this is that he identified that while I'm bringing this up here, I want to be clear, I am not issuing a waiver. Because by bringing this up now, you might think that when I'm bringing this up now and I'm mentioning my knowledge of this thing, that there's some sort of post hoc type of waiver that I'm issuing by bringing this up in open court right now. No, I want to be on the record here. This is not a waiver because we don't agree with this happening. And that's why they say, although Scudder and his counsel both were present when the judge announced the intention to speak privately in chambers with the witness, they raised no objection. When the judge and witness left the courtroom to go to chambers, Scudder and his counsel raised no objection. Again, when the judge and witness returned from chambers, Scudder and his counsel failed to object. Moreover, Scudder and his counsel failed to ask the court reporter who accompanied the judge and witness into chambers to reveal what had been said in private. In these circumstances, we conclude that counsel waived the right to be present for the meeting in the chambers in the presence of Scudder, who acquiesced in the waiver. So the point there in Scudder is because of the actions taken before and after the ex parte meeting, there's an implicit waiver in the Scudder case. And
okay, well, let me break this out a little different. Okay. So you've got the rule of law is that the defendant has a right to be present and hear all critical parts of his trial. This is a fundamental right in the due process of law. Okay, so the defendant has a right to be present when those discussions are being had. All right, that's the area of law. The rest of this just talks about waiver and applying this rule to the present case. The defendant and the defense attorney can waive it, and they can waive it by acquiescence. That's why he says, he starts out, he says, I'm not waiving anything. In fact, I'm bringing it to the court's attention and saying we expressly do not waive this. So they're just making sure they don't lose like Scudder did. They're saying there's a problem because we have a right to be present and our rights were not respected here. And Judge, you were in on it.
Right. And but you're correct to point out that the default is we start with this is impermissible. The only way it can become permissible is via a waiver. And there might be, and the Scudder case might talk about different ways that there are a waiver, but those facts are not relevant in this particular scenario.
It doesn't matter in this situation because
we have
the defense is not waiving anything. So therefore we're back to the rule, and the rule is those first two sentences.
Right. Correct. So let's go a little further here with respect to the exchange between Brian Steele and Judge Glanville.
I was told if this is not true. This court
Mr. Steele,
handed
ask
Mr.
me.
Copeland.
Tell me how you
perjury.
got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Proprietary information, for those of you who are not familiar with the term, is information that belongs to one person or group of persons that's not meant for the general public. And that's why he's asking, why would that information that you're holding an ex parte meeting be proprietary? How the heck that doesn't even make any sense. What the hell are you talking about?
And then the judge says something here. He says, well, I had this ex parte with a party. No, that is not true. The state is the party. That's a witness. That is a witness. That is not the client. That is not a state's client. The state does not have a client, but the people of the state. They have an obligation of fair play to the people of the state, and that includes the defendants.
Right.
And so for the judge to say, well, I was talking with the party here. No. That's wrong.
Right, because it's true, a party was there, but there was a witness there also. The other thing that to me is weird is normally when there's an ex parte meeting, the judge that's certainly not going to be considered proprietary information. Quite the contrary, the judges tend to be very forthcoming, saying that it was proprietary. I'm calling to the other side's attention that there was an ex parte meeting. And perhaps reveal whatever information the judge can to explain the nature of that meeting and why it is that it had to remain in camera outside the view of the other party, as opposed to the defense counsel bringing it up to the court. Like the fact that he has to unearth this and the judge is looking at this proprietary information is backwards.
Yeah,
that is ass backwards.
What reason is this information confidential? In what way does the defense not entitled to this information? That's baffling to me. Like you said, the court should be coming and saying, I just want the defense to know that we came in and we had this. They should have laid. That's the kind of thing that judges are very careful about generally. They're
I just said exactly. They're always very careful about that. I just want to remember.
But usually it's something like this, and this is how outrageous this is because I've had judges come in and says, just before we start, I want defense counsel to know that the state attorney called me this morning about a scheduling matter, about a motion to be heard. I said it for the, does defense counsel have any objections since I said it on Thursday, and you weren't present? Because it's scheduling matter, right?
Right.
And the defense will say, oh, no, but it's like that. This is a whole different bag. This is a witness on the stand who's testifying, who is being manipulated, threatened, extorted, have promised.
Yeah.
What's going on here? I mean, what is going on? And how is it confidential?
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said actually all of the defendants and then all 26 people are disposed of. If that's true, what this is, is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele,
I'm
I
doing
still
what
want to
everybody
know,
should
how
do.
did you,
And I want to point out here what he's angry about is it seems as if the prosecutor improperly twisted their arms by threatening, I'm going to throw you in jail unless you basically pony up.
Yeah.
So
that's explicit Brady material, by the way, which is there's no motion required. That's an obligation on the state to disclose that to the defense immediately. But I don't know. But did that happen? I don't know. But obviously, he's saying that why is this guy all of a sudden wanting to testify and going to change his testimony? And we don't have that to cross-examine it with it. This is just a complete and utter disaster.
Yep.
upon this information? Who told you?
What I want to know is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this
I
information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering that
Attorney-client privilege, unless you were in my chambers, that's the
I'm-
only way you can figure out.
I am
I
telling
tell you what, I'm going to give you 5 minutes. If you don't tell me
You don't
who
have to.
if you don't tell me who it is, I'm going to put you.
Well, let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information
I don't
supposedly
answer.
from my chambers? Did somebody tell you?
I'm not. You should have told me.
Right.
Yes.
Exactly.
Yes.
Exactly. Oh, this judge.
Continue.
You got 5 minutes?
This is what I was told. Mr.
Yes.
Copeland, Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
They're trying to take his notes. Look at this man here, lead
This is-
attorney, my brother. I would. If
Hey,
you
lead
want to
attorney.
pop in here to talk to pop in here. I'm constantly raving about this guy here. Now he's
He
here.
is very. I watched some of his stream on this today, and he had a very good guest on from Louisiana. And he was. And these are Georgia people, so I'm just a Florida lawyer.
No,
This is like Georgia folks.
I'm gonna recommend you all sign up to lead attorney. The guy is smart. He's based. He's entertaining as hell. He's just awesome. So yeah, I highly recommend.
He's a lot better looking than us.
Well, I don't know about that, but
Well,
he's. I mean, I'm not trying to. I'm Steve. Come on, you're the picture. You're pretty much Cassiopeia. Wait, was that the right one? Did I get the right one?
I don't think so. It's all that touch up, but anyways. So
Anyway.
yeah, it's great stuff.
But I'd love to get you in here, lead attorney, if I can, sometime soon. So hook up with me, brother. But yeah, so that's where the judge took a break, and he's like, okay, look, I need to figure out and look up the case law that you just cited at me, which is almost definitely what he was doing right there. He's like, go look up Scudder. Tell me what Scudder says. I need to know what Scudder says, because that's what I'm sure judges do when they storm out, and he's like, wait, am I in the wrong?
Here's where the judge should have gone. Okay, now he's probably angry because he got caught. All right, so he's responding in anger, and his way to be angry is to push. So he backs off. He walks off the bench. Good move. Cool off. Think. Calm down. You've got a defense attorney who is putting something on the record, and he's saying, I can't answer your question because of attorney-client work product, attorney-client privilege. I am in a conflicted position. Now, maybe he's right, maybe he's wrong, but that judge should not be determining that.
So attorney work product is generally generally we're talking about findings that come as a result of the due diligence efforts of a particular counsel. So it does tend to be protected. So and he's supposed to. There are rules of ethics which we're going to look at shortly. We're going to look at these rules of ethics shortly. So drop a red as I drop a horn for the red. We'll get to that in a second. But normally, work product is something that you are obligated under the rules of ethics, and it's. I mean, I don't know if work product ends up
put it this
rules of ethics.
Forget that.
But
let's just forget it.
That's proprietary. That is proprietary. Meaning, when what a attorney creates through their due diligence, that is proprietary. That they actually have a right to keep from others. Now, I'm not sure though if a judge directs you. This is going on a little bit of a limb, and I credit him for having the cojones to go on this limb, because is the judge in the wrong here? Yes. Is the judge trying to cover his own butt? Yes. At the same time, there is a general understanding that when you're inside that courtroom, it's almost as if like it's his house, and what he says tends to go. Now, if it's unconstitutional, if he's directing you to breach your code of ethics, I think that he's got a very strong argument. And this is where I'm going to ultimately, I don't want to ruin the rest of the show here. But I think what we're going to end up coming out, at least I'm going to likely come out, is that the judge here is grossly abusing his discretion in how he's conducting this court.
You want a defense attorney who's good on the law, on their toes, on their feet. He never raises his voice. He's not calling names. He's not using curse words.
Right.
He's doing his job as defense lawyer. And he is saying, I have ethical obligations. And he's saying, I am ordering you by the raw power of my court in order to put you in jail to violate what you think is your ethical obligation. That's what I'm going to take my power and my gavel and crush your ethics. Well, Judge, you might be wrong about that. And in fact, he is. But let's have a little humility on the part of the judge and say, you know what? I'm going to respect your. Let's set this for a hearing to answer that question. Let's deal with what's in front of us now. But he is using that ethical thing, that criminal contempt sanction, in order to overrule and basically ignore the real question that's in front of him that has to do with those defendants and this trial.
And he's about to cite in this next clip, he's about to cite what he referenced in this first, which is his obligation of confidentiality. So we are governed by rules of ethics, because we're in a type of profession where if you don't give us rules of ethics, it's going to be the Wild West. So there are rules of ethics.
What if, for example, the defendants were communicating through their jail thing with his client? What if his client told him this happened and he learned it in the jail? Back in the jail, they were whispering, "Hey, man,
I think between you and me, I think he slipped. I think he accidentally slipped when he said attorney-client privilege.
Well, I don't know. I'm just saying that it's
because
it's
that
possible.
would be attorney-client privilege.
Sure, it would.
But when
his client
says it's attorney-client privilege, that means you didn't hear it from a clerk, you didn't hear it from some other attorney, you didn't that essentially you heard it from your client, and then the obvious next step for the judge to come to is, well, where the heck would your client have heard it from if not from the defendant, if not from the witness himself? Which
now he's having contact with witnesses, and that's from. So now he's basically telling that he's saying my client committed a crime by doing this, or it could be a bailiff, could be a court reporter, it could be a JA, it could be the attorney for the other guy, it could be him sending him a note. I mean, there's a million ways he could find out, but when he's saying I have an ethical obligation not to disclose this, the judge needs to be very careful, because this is not some crazy defense attorney. This is a very skilled and thoughtful and intelligent defense attorney, and there ought to be a little bit of respect to what he's saying in that courtroom. But instead, he wants to plow over him.
And it's true, and supposedly he has a fairly sterling reputation. So in the legal community in Georgia, it's not like he's some fly-by-night attorney just showed up yesterday. So when he's asserting that there's
and good defense attorney, like prosecutors and judges, should be kissing their boots, because having a bad attorney on the other side can cause you all kinds of problems and appeals and clients that are wrongful convictions and all kinds of things. You want good attorneys, but they see that as a threat because they're used to people bowing and kissing the ring.
Shout out to the lead attorney. Thank you, Marcelechka. I appreciate you.
Is this the guy from is he from Louisiana?
I'm not sure. I don't know if I've ever seen Marcelechka before.
I think this might have been the guest that I was referring to. He was really good and he was great, but he doesn't have a YouTube or any kind of channel. I don't think. I hope I'm not just, assuming, but if you are, salute. You were excellent on Lead Attorney Show today.
And I certainly appreciate the patronage over here. So thank you much. It's not a leak. It's a whistleblower. This is Justin Wright. Has not the court lost its elevated status as a court because of the judge's actions? They don't lose that status. They don't lose that status. They retain that status no matter how poorly the judge conducts himself. So, like I said, I think this was a gross abuse of his discretion. And because he abused his discretion, I think that the attorney ultimately will end up getting away with a lot more than he would when this is being reviewed by an appellate court. The default we tend to start with, though, is you always sort of like you're really going on a limb when you defy a judge in his own courtroom. I that's
But I think
the
there's
yardstick.
there's got to be a motion for disqualification, and the judge has got to be disqualified. That can be interlocutory appeal, and I think this is a mistrial. I mean, what this judge did created a mistrial.
Oh, I agree with you. I agree with you that this.
So I don't think we'll get to appeal.
By the way,
I think we got to start it over from day one.
To be fair, the mistrial really happens when he brings that witness into his room.
Right.
It happened before this exchange. That's the grounds in the mistrial, because all the stuff that happens here in the back and forth, where the judge seems like he's desperately trying to cover his tracks, and he's trying to deflect from his own wrongdoing by implying that there was wrongdoing by a third party that he's looking to investigate. All of that doesn't really impact the trial itself, so as long as it doesn't interfere with his ability to defend him, which we'll talk about that later with respect to the ability for Brian Steele to give proper defense to his own client. But assuming that gets remedied before there's any impact on that representation, all of this could have avoided a mistrial. But the one thing he really is going to struggle with to avoid a mistrial is, what the heck are you thinking bringing a witness in there ex parte in the middle of his testimony? He's considered as if he's still up on the stand.
I've never heard of that happening. I mean, that's crazy stuff.
Yeah, and I think the judge perhaps lost it because he realized what a big screw up it was, and I think that's why he's like trying to ferret around to try to figure out exactly where that leak came from.
Well, he's frustrated because he's like, the witness has been granted immunity and he's not obeying the court's order to testify, so he's used to getting his way. You will do what I say, young man. So he brings a prosecutor in, and they're strong arguing him to get it, but that's not done. You're the referee. You're not a player.
Now, with respect to the professional rules of conduct for the State Bar of Georgia, just bring this up real fast here. He's going to cite Rule 1.6 in this next clip. He's going to cite Rule 1.6, subsection 5, which says that the principle of confidentiality is given effect in two related bodies of law: the attorney-client privilege, which includes the work product doctrine and the law of evidence, and the rule of confidentiality established in professional ethics. So that means when his work product now does attain a level of confidentiality, it's not just proprietary, but it does attain a level of confidentiality according to Georgia's rules of ethics. The attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence. The rule of client-lawyer confidentiality applies to situations other than those where evidence is sought from the lawyer through compulsion of law, but this is really more about confidentiality of the information, which applies not merely to matters communicating confidence by client, but also to information relating to the representation, whatever its source. A lawyer may not disclose such information except as authorized or required by the rules of professional conduct or other law. The requirement of maintaining confidentiality of information relating to representation applies to government lawyers who may disagree with the client's policy goals. So the point here is that he's saying that because of this section over here, confidentiality of information applies not merely to communication and confidence, but also to all information relating to representation, whatever its source, that he's not allowed to share this information with anyone, and that doing so would be a breach of his ethics. And this is a pretty strong shield for the lawyer to stand behind in his claim that this is further abuse of his discretion. You're basically pushing me for reasons that don't really that are unwarranted into disclosing and breaching my duties under the rules of ethics to maintain confidentiality. So I think that he's doing. I think that this is a pretty strong shield, because this is what's supposed to govern us. And for him to say, "Well, look, I'm standing behind this," instead of listening to what you're directing me to do, is a pretty. It's not merely a strong shield. It almost underscores how wrong the judge is in what he's trying to do. Like, why are you trying to get this out of this guy right here, right now, in this moment, when you're being exposed for engaging in conduct which is sus as hell? So, but we're gonna get into the actual. Now that we've looked at the rule that he's about to cite, let's pull up this. This is going to be the lengthiest video of the day, and this is the back and forth exchange between Glanville and Steele.
Okay, Mr. Steele, would you take the podium, please, sir?
All right.
Where he just doubles down and doubles down.
And triples down and quadruple. I mean, he just keeps going harder and harder.
All right,
But
Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it.
What?
So I'm going to ask
Really?
you again.
Really?
And I respect that. And it gives me no joy, but as you know, Georgia rule of professional conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, I'm just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information.
why?
Don't tell me how you got the information. I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah, and that's why I raised it. It is that serious that we should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
It's not at all the same. Not at all the same. By the way, from my recollection, there's a great question by Kimmy Hunt, because we all remember the Fani Willis proceedings when Natalie Merchant had that whole thing, that whole back and forth. My recollection is what happened there in the middle is Terrence Bradley kept saying that he couldn't share it because of attorney-client privilege, and kept going on and on, privilege every time he was asked a question by the defense. And then later on cross-examination from Abby Cross, he claimed something else that he had claimed unrelated, that was attorney-client privilege. He ended up spilling some of that, and it became clear that that wasn't privileged. And that made the judge very concerned that he didn't understand what the heck privilege means. Just understand how insane that is, Steve. The guy was a taint attorney whose job was to figure out where privilege attaches. Like the state hired him as a taint attorney a taint attorney has nothing to do with order of mendacity. The tainted
It doesn't have anything to do with taint either, right?
Right. Well, that's what I meant by order of mendacity.
Yeah. That's more delicate.
Yes. A taint attorney is basically supposed to look at if they seize, let's say, information, let's say an attorney's phone as part of like some raid. So they go through it to see what part. The taint attorney is supposed to be an independent party, is supposed to see which parts are privileged, which parts are not. So the very dude who clearly displays on the stand that he's one of the few attorneys on earth who has absolutely no clue what the term privilege means is the one that Fani Willis hired from Nathan Wade's firm. The one that Fani Willis hired to try and assess when there is and when there is not taint. To me, that's friggin' hilarious. But to answer your question, Kimmy, my recollection is that Judge McAfee said, I'm going to have Bradley in my chambers together with the prosecution and defense. It's not ex parte. So that makes it is unorthodox to do that in the middle of defense, but he wanted to question him to really find out what he knows about and what he understands and how he's defining the term privilege to verify whether or not he had been misapplying privilege when he was refusing to answer questions in his earlier testimony. So, but the fact that it was not ex parte changes the entire dynamic because everyone has a chance to see what Bradley's saying in front while he's sharing it with the judge. It's very different. It's a great question, but I believe that I'm factually correct in that. And that, assuming I am factually correct, it changes the entire landscape as to that meeting with the witness.
And it's interesting that the judge just said that the state requested that they ex parte, they talk to that witness in his chambers with him present without the defense. So they did. He just confirmed that this happened. And it was at the state's request that the defendant or the guy on the witness stand, the witness, was talked to without the defense present. He just admitted that right there.
Yeah. Now you share with me this rule 3.4.
Well, that was Gene Splice was very good and shared that with me, and he nailed it. So I shared it to you because I think it's worthwhile looking up and reviewing about what is allowed in ex parte and what is not. And you'll note that the exceptions are what I talked about, the warrants, for example, and scheduling, not interrogating witnesses while they're on the witness stand, while they're testifying to intimidate them. That's ridiculous.
Yeah. I'll see if I can pull that up shortly. Let's go a little bit forward here in this while we're doing this.
Ask this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not. I'm
The
trying
No,
to.
issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're saying, you're threatening me with
the
contempt.
privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
You don't know that. You don't know that.
Reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not
If you knew
merely
that to be the
to
case,
matters
you wouldn't be asking the
communicated
question.
in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, or you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not sub and substance, but I'm telling you I can't do that under the bar rule.
All right. Well, I'm going to hold you in contempt. Wow. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you some in substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
If you have an idea, why are you asking him? Why are you asking the question? If you actually do know. He's assuming, it sounds like he assumes that this guy had his ear to the door of his chambers or something. What the heck does that, what do you think it's like, I have an idea.
How you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to, listen, I told you the first time, and I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
See, now he's assuming he eavesdropped.
And why is he not entitled? Maybe we should look at the rule there, because he's saying you're not entitled. He just said it. You're not entitled to hear this information at this time. There's a witness on the stand. Yeah, so look at that. It floats in there magically. This is exciting.
Rule 3.4, fairness to opposing party and counsel. A lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not counsel or assist another person to do any such act. So,
wait a second. No. Did you? I put the link in the chat. That's not it.
Oh, did you?
Yeah. Look in the private chat. Yeah, there it is. Go down to there. Go down to 3.4. And this Gene Splice found this. This wasn't me. So
I'll do a little control F here. Mm-hmm.
Assuring fair hearings and ex parte community and averting. That means avoiding ex parte communications. Assuring fair. This is the Georgia Code of Judicial Conduct.
So that means how judges are supposed to conduct themselves when they're in a courtroom.
In Georgia.
Judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside of the presence of other parties or lawyers concerning a pending proceeding or impending matter, subject to the following listed exceptions.
Okay, so the rule is shall not.
That's right? The default. That's
the
where we
judge
start.
shall not. We shall not engage in this. Now, there's a few exceptions, and let's just look down. But those are very particular exceptions. So one is go down, not commentary.
One says judges shall immediately stop any Oh, you want me
Okay.
to go down to the exceptions?
Yeah, you could do that. That's the
All right.
comments.
Well, I say where circumstances require ex parte communications are authorized for scheduling administrative purposes or emergencies that do not deal with substantive matters, which that's clearly not this.
Nope.
And we go down to 2. Judges may obtain the advice of a disinterested expert on the law. That's not what we're dealing with here. We're dealing with a witness. Judges may consult with court staff and court officials whose functions are to aid in carrying out adjudicative responsibilities, or with other judges, providing the judge makes reasonable efforts to avoid receiving factual information that's not part of the record. Again, this is not that. Judges may, with the consent of the parties, confer separately with the parties or the lawyers in an effort to mediate or settle pending proceedings.
And there's no party here. It's not a party.
And judges may initiate, permit, or consider any ex parte communications when authorized by law to do so, such as issuing a temporary protective order, arrest warrants, search warrants, or when serving on therapeutic, problem-solving, or accountability courts, including drugs courts, mental health courts, and veterans courts.
So we don't have that either.
We don't have it. We don't have any of these things here. Let's see. Number 6 is if a judge inadvertently receives.
It's not inadvertent.
The judge shall make provision promptly to notify the parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. This is what we were talking about. I wasn't familiar with Georgia procedure, but I was talking from my own experiences that whenever a judge ends up having any sort of ex parte communication, it's happened to me numerous times that a judge will be like, the other side came forward and they had an ex parte thing, and this is what they might explain what the overall nature of the application was, but they're supposed to come to steal. If, in fact, there was propriety to this ex parte communication between the prosecutor and the witness together with the judge, which I and Steve are at a loss as to what set of facts would give credibility to that claim from the judge, to come up with a set of facts like, okay, maybe this is what happened, maybe that's what happened, that's why they couldn't have steel in there. It's very hard for us to come up with something.
It's not accounted for by the rules. This is the rules that govern judges. There is no basis for him. The state comes and says, we want to ex parte with you and the judge and this witness who's on the witness stand and exclude the defense.
Yeah.
That's not allowed.
And the point of this, by the way, is if someone tries reaching out and it's unauthorized, I missed this key word here. It's unauthorized ex parte communication bearing upon the substance of the matter. In that case, he's supposed to tell the other side. So what the heck is happening here is just is ponderous. And
this is basically, he could lose his judicial seat. He could be removed from the bench for this.
Yeah. Yeah, this is really improper, and for him to claim that that's proprietary information, there's no jurisdiction for him to make that claim. He has no authority to make that claim. He has that right because he is the king. He's the governor. He's the king in that courtroom. But he is bound by the rules of judicial conduct, which it seems fairly evident here that he completely disregarded and then engaged in abuse of.
And I would
call it to his attention.
If I was the defense attorneys right now, I would be getting the transcript of this hearing where he's admitting that he's doing these things. I would quote that Georgia Judicial Conduct Code, and I would move to disqualify this judge from this thing. And he's disqualified. That's a mistrial. It's over.
Yeah.
New trial.
No, just the judge and witness. No state, no defense in Trump trial. It was just the judge and the witness. So maybe because it wasn't
Trump trial is not even law.
In that scenario, he also told them that he was going to be doing it. Now, he's talking. This is going back to the question that was asked me by Kimmy Hunt, who said, "Didn't McAfee have Bradley there?" So I recollected that all sides were there. Rhonda's correcting me and saying I'm factually incorrect. That she says that there was no counsel there. No counsel there is better than one side being there. It's much worse when you have one side there, especially given the nature as to what Brian Steele is alleging happened there, that in that conference, they started threatening that, hey, if you're going to plead the fifth and you're not going to come forward and testify, that we can hold you in prison for 28 days or whatever, in order or for the balance of this trial because you're refusing to testify, which is what he's alleging is what happened in there, which sounds crazy. That a prosecutor would actually make that type of threat, especially a trial of this nature, which we have no idea how many months this thing is supposed to be going on for in the future. I mean, it's an astonishing threat for a prosecutor to wield in front of a judge. in front of a judge, and that this is happening without defense counsel being alert, knowing, being permitted in there, or even being alerted to it.
Intentionally concealed from the defense.
It's
it was
just
being intentionally concealed from the defense, and the
Yeah.
judge was in on it.
This really feels like a mistrial. This
It is a mistrial. It's a mistrial. I mean, come on, it's over. This is
Yeah.
ridiculous. I mean, but it's absurd, and the judge needs to face severe consequences. Now, I'm going to not absolve the prosecutor because this judge have been a really good judge. We're seeing him as one of his worst moments. I don't know. I'm just commenting on what I'm seeing today. But the state, by setting up this endless, complex, difficult trial with all these defense lawyers, you are creating situations that's going to test your judge to the limit. And most judges could not handle this kind of trial. There are a few, I know some, but
you know whose lap that lands in?
Yes, Fani Willis, right?
Miss Owner of Mendacity herself.
Unbelievable. So it's another reason that prosecutors need to be careful in bringing these complex trials. You can simplify these things. First thing is try them one at a time, serially.
Yeah.
Judge, listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
From whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then we can
Okay,
talk
well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
well, then, other than
Answer
if
that.
you
I'm the
were sitting,
attorney-client.
unless you were sitting in there with a recorder or Miss Love or Miss Hilton or one of the deputies gave you that information.
Oh, so we have a lot of suspects.
Shot you a rough copy of the transcript. There's only one other person that's left.
Well, Your Honor.
And if that person
That'd be
gave
Copeland.
you that information or shared
That'd be the witness himself, Copeland, right? So that's what he's basically insinuating he thinks it is.
And
He's like,
why
I'm
is
ruling
he-
out all these people, and I'm left with Copeland. That's what he thinks happened here. That Copeland told young thug, and young thug told his attorney. That's what he thinks happens. Which, assuming he is correct, then he should know he's directing him to violate attorney-client privilege. That's essentially that he knows that's what he's directing him to do. Which, what is the basis for that? What is the justification for that? Yeah, have a hearing and talk to Copeland and find out whether Copeland spilled the beans in violation of some directive from the judge, which you have to ask why the hell the directive was issued, right?
that information with you. She probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have
When I got this information.
I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's
All right.
really it.
He can go into custody at this point.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your I'm going to deny your
Coming.
motion. I'm going to deny your motion.
I
for
understand that you
mistrial.
spoke with a
And
witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you
Oh!
influenced the witness based upon information belief, and I'd like.
Oh, right there. Right
Just
there. I mean, it was implied all throughout, but it's right there.
This is judicial tyranny.
Yeah.
And this is judicial tyranny. Here's the big boot of the law here he is with a gun, going to put the cuffs on the lawyer for the defendant. This is a mistrial.
Yeah. Yeah. Fulton County is the bastion of excellence in
This
law.
is law, right?
Judges
Who knew?
obstructing his authority. The judge is projecting blame in order to obfuscate his own personal guilt and shame. Well said, Snuggle Struggle.
To have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine. But you're
All right.
acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay.
Why?
That's
No,
another
that's
day.
for
In the
today.
first place.
That should come
That's
first.
for today.
Yes.
We are, this guy's on the stand and I'm supposed to cross-examine him. And you've been having secret communications. And what did you say to him? Now, why is he saying what he's saying? The jury needs to know what his influences are.
Yeah.
That's bias. I mean, come on. Oh my God,
crazy.
this is just terrible. And the bailiffs,
The bailiff's doing his job. You know, he's
ordering.
Yeah.
But it's very, very.
It's not like the bailiff is going to mutiny on the judge in this situation. So I don't hold any accountability to the bailiff at all. He's just doing it. He's a 9-to-5 guy. He's like, this. I got to follow whatever the judge tells me to do. So, you know, he's following orders.
I didn't know about this.
That's for another day. So
I raised it as soon as we found out about it.
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele,
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have
Lawfully asked you to
communication
hold?
with a witness who's been sworn.
What does that mean? Lawfully asked you to hell?
I mean, the defense attorney is right on the money.
Yeah.
The judge is obfuscating, and I don't know where he's coming up with this stuff. It's just
we're going to look at his order soon.
You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it supposedly.
The state wishes to be heard.
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
And you can't hide behind, yeah, but the thing is, I think you got this information.
And 1.6 is the rules of
Somebody disclosed
confidentiality we
it to
pulled up
you,
before.
and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there. Unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
that leads to be told. But
right now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
and I want that information because
Just
Mr.
stop.
Williams' constitutional right on the
Just stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1,
because you've already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Love.
Can I also say that before she gets to say, there's also the defense has a right to put stuff into the record, to make their objections, and the judge is saying stop. You know, this is what they do. They love to bully. Now, a lot of times it doesn't matter. And see, judges are used to a lot of defense attorneys getting along, playing smooth, working for the plea, agreeing with the judge, picking their battles, right? But this is war because it's at trial and they want to put people away for life. So this is war. So you can't expect compliance just bullying through people. And what this guy's doing is he has a right to put the record. He has to put his statements, and he's cutting him off and he's shutting him down. He's not letting him put the full statement on the record, which is improper.
Well, I think that's with respect to your question about TRO against the talking to the witness. No one's supposed to be talking to the witness.
Nobody, not
the defense, not defense counsel, not the prosecution, not the judge. Nobody's supposed to be talking to him. Literally nobody. You don't need a TRO. It's just like standard. And I think the judge here smells that his client has spoken to the witness, and that's how he knows this information. He's trying to get him to confirm that. I think that's what he smells.
Yeah,
so
and he's offended because his order's not being obeyed. And there's contact. That's what he's like you say, he's smelling. But you know, if this judge, it's not about you, judge. It's about the parties that are at trial, the state. You're a referee. It's not about your ego and about your orders being violated or anything else. Deal with that some other time. This is a jury trial for the conviction of people who are supposedly accused of committing terrible crimes. So make it clean. but they're not. It's like he's injecting his own ego into this thing.
100%. What do you think about the concept of, let's say Young Thug had threatened him? Would that create a situation for justification for there to be an ex parte meeting between the judge, the prosecution, and the witness?
The defense has a right to hear that. They need to be the attorneys, not the defendant's not going to be in there. It's his defense attorney's going to be in there.
Right. And right. I that's what I assumed you were going to say, but I think it's a good question that a lot of people might be curious about. So let's go forward here.
And Your Honor, excuse me.
I'm going to look this up.
And I know I said this previously. Yes, sir. But we are not accepting any proffer from this law.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as the state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true.
No one's disputing anything he said.
We have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court
Okay, this is, I see.
A person for not obeying the court's directive.
So they were looking for a civil contempt against.
No, that's the civil contempt. Remember, because the client, the witness was on the witness stand, wouldn't answer the questions. The state granted immunity to him, said, now you're ordered to it. He refused, even in the face of immunity, refused the court. The court said, I'm going to hold you in contempt during the continuing of the trial until you comply. And he said, okay. So that was a civil contempt. But that has nothing to do with the defense's ability to be in on the discovery. What was discussed? You can't talk to that witness without the defense present and the judge initiated and concealing. What is the basis for concealing? We're talking about some civil contempt matter against the witness. Yeah, the witness who's testifying against my client. What are you telling him?
Yeah, it's kind of crazy when you frame it that way. I got to hit this up right here. Marcelechka. Negative, it wasn't me. He wasn't the one on TLA's attorney, on lead attorney's channel. Although TLA's channel is my home base. Well, I'm glad to have you come by for a visit over here.
Really, and very kind with the super chats. And this was the first time I've watched the lead attorney, and I was really impressed. And they're Georgia attorneys, so this is right in their ballpark. And he was complimentary of this judge generally, but he said he doesn't know what's going on with him today.
Mm-hmm. That's interesting. It's good to hear from someone who actually has practiced in front of this judge. So you sort of get a little bit more of a feel for his general temperament. 18 U.S.C. 242 needs to be dusted off. These corrupt judges and prosecutors need to be prosecuted. This made-up concept of immunity needs to stop. Yeah, and Anna's asking similarly, what consequences do you think this judge can face?
I think, first thing is a mistrial. He needs to be removed. It's retried in front of a different judge. Then there's JQC proceedings, which he could be removed from the bench for that. And then there's bar compete, so he could lose his bar license. Like I said, we have a judge. We have a judge that I happen to be familiar with in our local district who did some bad things on the bench and was sanctioned by the bar and removed off the bench and then suspended by the bar. So there could be bar sanctions. I think that would probably be the extent of it. Going further than that, I don't know. Of course, what the substance is, but those things are definitely possibilities.
Yeah.
But it depends on the Georgia bar. I don't know the Georgia bar, so I don't know what their predilections are and how aggressive they are against their judges. JQCs are notoriously friendly to judges to get away with just about anything.
Of course they are.
Well, of course they are. Yeah.
It's like it's like you're asking cops to narc on each other. It's not going to happen. Defense could be excluded if they claim defense crime fraud, i.e., they help make the threats. Yeah, okay, fine, but that doesn't seem like there were threats based on what she's saying here. The DA love is bad. She has text exposed with another witness and her. Oh, okay. Well, maybe I won't see it yet. Maybe we'll see it.
The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does.
Really?
And regarding
what does it stand for?
Legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants,
why?
We cannot make the kind of assertion I'd be inclined to make. So
what?
Before making the next set of assertions, I would need to know how that information was made privy to them.
Why?
To counsels for the defendant.
Why does it matter if he has bionic hearing? Why, or if a clerk told him, or if the witness himself told him? Why would that change? What, I don't understand.
This is just a word salad of garbage.
It is. I think she's desperately trying to give justification to where the judge is coming from here, which is that the next step in this process is I need to know how you know this. And she's trying to find some sort of justification for that. She doesn't explain what Scudder stands for, if not for exactly what it says plainly on its face. And for those of you who came late, we pulled up the Scudder case. The Scudder case, we can summarize it over here. Scudder correctly asserts that criminal defendant has the right to be present, to see all and hear all critical parts, fundamental right, and a foundational aspect of due process of law. And it's a right that may be relinquished. However, if the defendant personally waives it in court, then they don't have to be there.
You can skip that part. It's just those first two.
The point here is that you cannot, and this is specifically dealing with a witness, with talking to a witness in chambers, ex parte, that says, hey, that's what the Scudder case is talking about. So I don't know how she thinks, or she's trying to pretend that Scudder isn't precisely on point.
So in this case,
you must have all sides there.
And Scudder says that this was just the judge talking with a witness. There's no DA. Here, there's one party, which, like you said, is worse.
Much worse.
Yeah.
Anna says, if that's the case, they should have included the defense team on the meeting. There's a reason not to warn the defense team. If it's inconspicuous. Also, hi, lead attorney. Hey, y'all missed NY Arena. I got it in the end. I got it late. That was 18 USC 242 that we got. But I got it. I came back to it. I didn't miss it. And Durham says, if there's potential investigation over ex parte, isn't the judge asking after witnesses and holding defense in contempt now obstruction? There's potential investigation over ex parte. Isn't the judge asking after witnesses? I don't know if it's obstruction, but it seems so corrupt. It feels as corrupt to attorneys as it feels to any layperson. That, like, why the hell is this becoming the focal point?
I explained it to my wife, and she's got it in 5 seconds.
Yeah.
Why is this judge, who's supposed to be so great, so confused?
We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask
this is the prosecutor's
what the appropriate remedy is.
We'll try to cover
for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned We have observed a number of actions on the parts of a number of people that I am not comfortable
They feel invincible. That's what it is.
stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was.
Yeah,
I do.
everyone else knows.
Probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike
What did she say there?
everything that he
This
said
is
from the
just-
time he
What did she want? Anyone who's in listening shot of his voice?
This
What?
is just all garbage.
What
This
is
is
she
basic. I don't even know why. What?
I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot.
Oh, he's performing
of
for
his
TV.
voice.
Oh, what crap.
And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him
No way in hell
where
that
it
could be
was that
stricken.
he obtained the information that was made privy in counsel for this court.
All right.
That's
And
an assistant
regarding
district
Rule
attorney.
1.6.
Here we go.
Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with
They didn't
attorney-client
say that.
privilege.
She never said anything
And that
about being
is
threatened.
information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of 0.6.
Why would it not?
How
The
do
court
you
would
know?
allow me a
We
moment.
don't know that. We don't know that. The
Yeah.
attorney has asserted that it does. He has an ethical obligation to follow that rule.
Gosney
Hey, Ted. Hi, Todd Larson.
bought his
Okay.
books from my son's best friend who ended first year SMU law and
Regarding
is interning at Denton, Texas DA on public defense because of the use of his books. Cool.
Wow.
Thank you.
further
Thank you.
appropriate
God bless you,
remedies,
man.
Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this.
They seem
Apart
so
from what-
incompetent. The entire prosecutorial office seems like it's like they're all DEI hires. Like she can't make an argument that doesn't sound like word salad. And I want to be clear here. I want to be crystal clear. Okay. When I say DEI hires, the reason I'm saying that is because it's almost like they're trying to fill positions with people and they don't care. They're not screening for competence. And I know tons of very highly competent attorneys. I've met and some of every race, gender, creed imaginable. That's the point is though that if you're trying to just grab anyone you can to fill up your office, I don't know what's happening here. This is not English.
Well, the fish rots from the head down, and if Fani Willis is your assistant DA or your DA, you know who is going to be following that person into battle.
Yeah.
But it takes two to tango. Here you've got a judge and a prosecutor who are both terrible, and it's very difficult as a defense attorney. You got to be willing. I mean, I've had this battle. And it's like I've had a battle with a prosecutor and a judge who were both terrible, and we did everything we could. But it's like the railroad of injustice is very difficult, and you hope there's appellate relief.
Yeah, I mean, but appellate relief takes years.
Exactly. But
years.
this here should be a mistrial, and if he doesn't grant it, it should be granted by the appellate courts because the judge has made himself a witness.
And I look at this, and I'm telling you right now, the best judges I've ever appeared in front of, my favorite judges are minority women. And I know I say this, people are like, really? And I'm like, no, they really are minority women. And after that, it's actually, and what I've found, this is my own personal experience in my experiences in practicing litigation in New York. Minority women, white men, minority men, white women. That's basically.
I don't think that has it, because I mean there's a black defense attorney on the other side who is excellent. I love that guy too, the bald-headed guy. I don't know who he is, but he is smoking because, well, when the Steele guy gets held in contempt, he stands up and he's like, and pick me too, pick me.
I'm simply talking about judges I've appeared in front of New York. But yeah, you're correct. Look, I mean, you all heard me raving about lead attorney 10 seconds ago, right? He's awesome.
Well, I don't, racial stuff. Who cares? This is about the justice.
Once
and the
I
law.
said DEI hires, I have to make sure that I'm not taken out of context. That's all.
You will be.
Oh, I will. I know. I will. But what I'm saying is, I don't know what this woman is saying here. I don't know. And I have no idea what the heck is happening.
I'll translate. Okay.
I use competence. We're saying we need to look into this further. We have a different read. I can't explain to you what the read is, but we have a different read. We disagree about what 1.6 that doesn't provide a shield. All this stuff here there's no legal argument. It's just they're wrong, and I can't explain to you how they are wrong. And we need to research even further on the remedy so that there I can say his remedy that he's asking for is wrong. I mean, everything she's saying here just sounds like such hot garbage that I say to myself, I can't imagine how this person became an assistant district attorney and presumably lead counsel for the ADA's office in a freaking RICO trial. I mean, this is a RICO trial. You need to put your best. This has got to be your best up there. I don't know what's happening. I'm sorry. I get very frustrated when I see bad lawyering.
It's a genuine Joe rant. I stand out of the way. I get out of the way when the rant.
Yeah, I just get really bothered by bad lawyering. Fulton County isn't saying their best, corrupt AF. Yep. Hey, Judge, the illegal thing we did was leaked. Forget the fact that we did an illegal act and focus instead on being leaked. Yep, that's exactly
right. Anna nailed it.
She
said it. She said it in one sentence.
That's good. Yep, she did.
Yeah, that's
Cat Not Williams is not just a new member, but also gifting 5 memberships. Welcome to the following Cat and all the people who Cat Not Williams brought in here. God bless you. Thank you so very much.
Can you go back to, I missed that one chat and I talked over it and I feel bad. Can you go back to the one after that one?
Fulton County?
That one, yeah. Well, I think that was it. I'm sorry. I apologize to the super chatter because I talked over them and I did.
We sound like two skulls still
this one.
Each other instant after Dad is gone. Yeah, that was funny.
That one.
And Charlotte saying defense started to say he was CC'd on an email. Maybe that's how you found out. It still would be work product. Of course, all this is work product. All of it is. This is and they have no explanation as to why it is that Brian Steele is wrong. That's what's so gross about this.
The court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also,
this guy is great.
Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt. Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has 2 attorneys.
Okay, yeah, he does, but
the court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position.
You saw this guy already.
Yeah, he's great. This guy, see, I love it. See, this is like, I'm Spartacus. No, I'm Spartacus, right? I mean, the guy just got held in contempt and put in jail, and then the next guy comes up and says, "Now put me in jail too."
The judge here basically deciding, does he try twisting his arm? That's what's going through his arm. Do I threaten him with contempt also?
Right.
That's what's going through his brain right now. He's sort of, it's ping pong in his brain. So I threaten him with contempt also, unless he tells me what the source of their information is.
Now I will also make the point.
This guy's got balls because he knows
balls. Go.
He knows he's walking into a fire here also, and he's like, I'm being totally upfront with you, and I think he's almost daring the judge to throw him in jail.
As Mr. Steele, I am asking for a mistrial,
right,
as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
Right.
All right.
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well, I asked him, so I didn't ask you.
Yeah.
So.
Why is that?
I'm
gonna now go away.
I'll leave it at that. Okay.
Coward.
Ask him.
Throw him in jail too. Throw him in jail also. Coward. Because he knows this is him knowing he's wrong. This is him knowing he's wrong. Because if he would trust me, if he felt like he was right and he was disrespected by Brian Steele's refusal to bend the knee in his own courtroom, he would have told this guy to bend the knee. He knows that the ice he's on is so thin. It is so thin that he's probably cracked through it. That's otherwise, to me, he would have said to him, "I want to know what the source of information was." Yeah. I know. I'm telling you right now, he knows he's on thin ice.
I don't know. I tell you, never. I don't know. It's hard to say, but I love this lawyer here. This team. I mean, these are spectacular. This is spectacular. This is defense attorneys at their best. Courage. They know they're right. They're pushing the issue, and they're courageous in the front of everybody, the cuffs and the judge and the prosecutor, everybody, and the hate. And I mean, their clients aren't probably spectacular. I mean, their clients aren't saints, but they're up there doing justice. Thank God for good defense attorneys like this.
Amen. No, this guy seems awesome. Now, let me just get this real quick. Gosney! Shifted my son's PhD thesis in sociology to capital murder wrongful prosecution based on your book. He's fully funded. Thank you again. God bless you. Thank you.
I wonder if it's this book.
Death penalty designs maximum due process.
Yes, this is going to be released on June 21st.
Whoa! So check it out.
And this is what you need to check out. This one. I'm getting it. That's the fake cover. This is my draft. So
I have a shelf in my house here of Gosney books that basically that I collect here, and he's awesome. I highly recommend them.
Thank you.
More Steve, more often.
I
Amen.
know. We always say that when we're on, and then I get neglected by Joe.
I want you to know something. I bring you as infrequently as I bring you on. I think I bring you on more than anyone else.
Okay, well, as long as I'm ahead of the other team.
No, I'm it's like the only one who's even close is Branko. So
okay, well, that's good company. So I'm not complaining.
Oh, he's totally getting a chain.
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving forward.
By the way, if you forgot, Shannon Stillwell is the one that at the very beginning we showed Kenneth Copeland, the witness in question, who was in that ex parte meeting, that he was asked to identify Stillwell. He went like, "I got bad vision."
Oh, Raul Stillwell. I don't know Stillwell.
Shannon Stillwell.
I don't see it. Is the blonde guy over there? I don't know.
Is it that guy? Is it that guy?
The redhead? I don't know.
I'm not sure. I'm not sure. It's hard. I got vision. Things are blurry. I need a drink. Things are blurry.
A mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark.
Yep, you're still not talking.
I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in.
Right there.
My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case.
And he's picking that language, critical stage, because that's tracking the language from Scudder.
Exactly. This knows what this is the way you do it right here. This is good defense work right here.
Yep.
Not
And
all that
is
blibbity blob
cause
that
for
you
the
heard
meeting
earlier.
mistrial.
Right.
Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this may have also, this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness.
Right, exactly.
To this, in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these.
By the way, identifying him as a potential material witness is another basis to get him out. And not just have a mistrial, but to say that it cannot be his. Because if he's a witness, you can't be a judge in the case that you're potentially a witness. So that's another basis for them to say, F off, get out of this case. You're right. This is great lawyering. Here's to Joe for getting together Batman suing the law, figure out which is which. Thank you so much, Todd. You're awesome.
I want to be Superman.
Proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know.
We need answers.
Not in the dark about what happened.
How we got this information.
Meeting occurs with a witness that has been sworn in.
I want the truth.
We're not invited to the party.
Right.
So,
See, boy, that's
Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, same thing. You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the statements.
All right.
Good afternoon, Your Honor. Congressman Matthews, here on behalf of Mr. Marquez Huey.
Okay.
We are also adopting all the arguments that have been made.
All right, sir.
And this might sound like a waste of time, but it is technically something you need to put on the record. So this way you can be part of the whole mistrial rather than being excluded from that grant of a mistrial, assuming that it's successful, which they have far greater chance of success on this motion for a mistrial than most criminal defendants who bring that application.
That was by Attorney Max Sharp, by Attorney Douglas Weinstein. We were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an communication that was on the record, just in the point of just letting the parties know that there had been this particular.
Yep, you should let us know.
My suspicions that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court we believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. D. Williams? All right, thank you, madam. Motion's denied. Mr. Garner? Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. Once he clears the area, we'll go ahead and get started.
Okay, so here's the next problem. Okay, stop right there.
Yeah, we're going to continue. I'm not called.
Okay, see there. So this team is great. And see what he's doing now. You have just removed the defense attorney from the thing. He is now unrepresented by the attorney of his choice. Mm-hmm. And he's going to go ahead and put the trial together. He's going to go forward to the trial with the guy being unrepresented.
like in case there wasn't a mistrial yet, let's ensure that there's a mistrial by refusing him his right to counsel.
That's appellate error number one. I mean, the guy is denied. There's been judges have been removed. We had one in just south of me in Brevard County, which is my jurisdiction. I don't know if you remember the judge that the defense attorney, the public defender wasn't agreeing to any continuances and was speedy trial and everything. And the judge didn't like it. And he took him, says, meet me outside. He went and he cold cocked the public defender from behind, sucker punched him, and then comes back in and then continues all the hearings with all these defendants without the defense attorney present. The judge got removed off the bench, not for hitting the public defender, but for having hearings without representation.
Really?
Side. Yes.
Interesting. Fascinating. Yeah, we haven't gotten to this part yet here where Steele requests me the same style as client. It is a baller move. This dude basically became like the most popular defense attorney in the country in one day. He really did.
He's on my list. He's in
he earned it. He earned it today. Really
we ought to pitch in and give him like a Steel Balls Award, you know.
I'm not going to participate in trial without the steel.
You don't have that luxury at this point in time, sir. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue, we believe this germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
Respectfully, I will not. I cannot.
Sir, you have to.
You have to. I'm going to order you.
You're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't, but I'm telling you.
Why do you need the information about who the leak source is, rather than just giving them the transcript? What is the issue here? What is the issue? Like, it's so astonishing.
At this point in time, there is nothing that was given, said, whatever this morning that
we won't know that when we see the transcript.
Accuracy for some of the information that we.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that
at this point in time, you've admitted it. You've already admitted it. You said you had an ex parte meeting. So why is it relevant as to,
And so did the prosecutor.
This judge's foolish admission. His admission now makes the source irrelevant because now we know that there was this ex parte meeting. And that's certainly
and they named off, and the prosecutor got there and named off all the people that were in the room.
Yes, and I think the judge did too. He's like, well, it wasn't this guy, it wasn't this guy, it wasn't this guy. So who's left? Who's left? So the judge, this is astonishing. It's astonishing. And to answer your question here, my thoughts are intentional or stupidity. It's incompetence. This was incompetence. This was such a dumb move on their part.
It's arrogance, it's lack of training, lack of understanding of the proper roles of the party, lack of understanding that this is a trial, it's an adversarial proceeding, the role of the defense lawyer, the role of the judge. It's ignorance and unprofessionalism and unethics.
I'll say it. This is a prosecutorial team which was not trained by Steve Gosney the way the Miami prosecutorial team is going to be trained, because Miami prosecutorial team that's coming in will never make this mistake of bringing an ex parte witness in. This is something that Steve Gosney is going to be showing them clips of this, that you don't want to be the prosecutorial team in this scenario. So never ask a judge to do this.
Exactly. See there, Joe knows.
Yeah.
Thank you.
Could the defense request an interlocutory appeal to have the judge removed? Yeah, I mean,
that's going to happen.
Yeah. If someone was listening outside chamber, does not phone booth exception apply? No rights to privacy if you don't create it. Well, I mean,
there's no right to privacy. There's no attorney-client privilege. There's nothing. There's no reason. There is no reason that the defense should not have. The defense has all the reasons to be in on that meeting because they want to hear what the witness is being told by these other parties.
Yeah.
There is no reason for the judge to keep it confidential.
100%. Pantene coming soon. Pantene save the day and infuriate the judge. I'm responsible for everything I do in my professional life. Judicial immunity is a farce. If this judge feared repercussions, I agree with you. I don't think he fears anything. Plus, they're brazen enough to held up in court. How can a judge ask to continue without the meeting information?
Right, exactly.
Yep.
Exactly. You're just this is creating so much error. If the trial, it's a mistrial. This is a mistrial. The judge has screwed it up. He screwed it up before he even came in. Once that ex parte meeting occurred, it excluded the defense. It was over. And he's gonna have to be forced off the case though by an appellate court in an interlocutory appeal.
And now he's just a bull in a china shop where every direction he goes is making it worse.
Yeah,
every direction he goes is just making it worse.
He can't bail himself out at this point.
Yeah,
is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that.
Yeah, we are.
That's sort of like, okay, wait a second. What if there was a cocaine deal? What if they had a big stash of kilos of cocaine that they're shifting between the prosecutor and the judge, right? And then the judge says, how did you find out about my cocaine deal? Who told you that?
Yeah.
I'm going to hold you. Do you tell me who said that? I'm going to hold you. Well, what about the cocaine deal that you were doing with the prosecutor there, right? Well, we're not going to address that.
What about the bribe that they handed you this morning?
Yeah, big chunk of change.
Who told you about the bribe? Who told you? We're not going to go forward until you tell me who told you about the bribe. It's like, what? Are you kidding me? It's astonishing.
Oh, violation of Mr. Williams' rights.
It's not, sir. Sir.
Is not.
That's not what happened. That's not what happened.
No, we only know what happened when we.
That's not what happened.
What happened then?
I'm just telling you, that's not what happened.
I'm not telling you. You're a witness then.
We are not obligated to simply accept that there's been no violation. We believe that there has been. And the only
okay, well then,
especially when you're not even admitting that there was a violation and having that meeting in the first place. So now we're supposed to take your word for it that nothing bad happened in it. That seems kind of crazy.
No, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Unbelievable.
So
this is embarrassing. This is embarrassing for this court and for our justice system. This is a sad
afford me one moment to confer with counsel regarding the appropriate remedy in this type of
Okay, all right.
Now the state's getting itchy. Like, I don't know about what's going on here. Because see, the state's job is to take a nice, clean trial and bring it through and crack that egg, guilty, omelet made. This is
forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel.
right.
And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Unbelievable. Very embarrassing. You know, contempt of court on a defense attorney needs to be reserved for very particular situations. You know, look, what happened? Remember the stupid guy that ran down all the people that represented himself, whatever his name was?
Daryl Brooks.
Yeah, it's like, was he ever held in contempt?
I'm not sure.
No.
I know he was muted. I know he was muted like countless times for being.
Oh my God. You know, it's like, you're going to put this guy. I mean, what is this? This guy is a
travesty.
This is a travesty. This is a great defense lawyer who's doing his job, who's following his ethical obligations, and you're going to put him in jail? I guess that speaks to our country now, doesn't it?
Yeah, I wanted to get because there was more to this. This is not done yet, because then there was more after this that I wanted to cover. Where he actually gives him sentencing, where people come in there and complain to him. I'm trying to find a link for that. So, so if you just give me a moment and just while I'm
I'll talk for a second, which I can do. I will be releasing Death Penalty Designs Maximum Due Process on June 21st, which is the date I will be unemployed. So when I go, I'm leaving the Public Defender's Appellate Division, and I've summarized all of my conclusions on the death penalty and Florida's death penalty statute, and summarized the constitutional attack. My book on death penalty debates is on the public policy argument, and this is why Florida's death penalty statute is unconstitutional as a matter of law. And this is a work I've been working on for about 2 years, training myself. It's a summary of death penalty history, death penalty federal case law, and issues that they attack in the federal level, as well as applying those federal laws to Florida's statutes. So that'll be released on June 21st. This is a test cover, not the final cover.
Yeah. All right. So what I have here, I had there were two other clips I had here. I thought that went through. I know that he has counsel that comes in here, because the Fulton County criminal defense crew, it was like a bat phone was rung, and they all rushed down to the courthouse to basically stand with Brian Steele in his silence, and kudos to all of them. Kudos to them for stepping forward and calling out this farce. So I had this clip here. I just sort of want to get in the right order as far as chronological. Whoops, my bad. As far as chronologically what happened here, I had this would have seemed to happen beforehand, because we see that Steele's still there, where he started yelling.
We started this whole fiasco out with whether the state knew that Mr. Copeland was going to take the Fifth Amendment.
This is a different issue. I don't want to deal with this. This was a different issue with the judge mouthed off. Give me a moment here. I still need another moment here. God. Where did I have this?
Sergeant Brown's everybody present? Needs to be present.
Okay, this is what I have.
All right, thank you for your patience, counsels. The court had an opportunity to reflect, and
so this is at a certain point. What ended up happening was, and I can pull this up here. If someone does, maybe someone has.
Well, here, what happened? I'll give a summary. What happened was that the attorney was then held in contempt. They call that witness to the stand, and he's going to testify, and they're going to start proceedings without that lawyer.
Not Brian Steele there.
Steele there, because he's in custody, right? The judge they're sort of saying, wait a second, there might be an issue here. And there damn well is, because you're having a trial without the trial defense attorney. And so he backed up and said, let me think about this. went and said, I'm going to take a 5-minute break and confer. He went back for an hour and a half and then comes back. And this is what he announced. This is his solution to his problem. There is no solution. The solution is mistrial, remove this judge from the case. But here, this is his solution, what he does. Because there's these other two attorneys that talk. There's two defense attorneys from the...
Ashley Merchant comes in there.
I don't know them. There's a long-haired guy.
That's the blonde. Oh, the long-haired guy.
And there's a blonde.
And Ashley Merchant is the blonde.
Who's Ashley Merchant? I don't know her.
She was counsel for Hector Roman, the co-defendant of Trump, and she's the one who brought the Fani Willis scandal to light. So that's why she's become nationally famous for bringing the Fani Willis scandal to light.
Okay, so, good for her.
Yeah. Let me see if this is.
Obviously, the governor should remove this prosecutor.
This isn't it here. I'm trying to get. You know what? Let me see if I can pull this up here. Grr. I thought that clip covered when Merchant came in, and because I didn't get away through it. All right. Well, this is initially he sentenced him, and then he says he rethought it.
How do I not know that? I don't know this because I try not to follow any of these cases or the news or anything. I mean, it's not like I'm an undecided voter.
I do want to see Ashley Merchant's argument. Thank you. I definitely want to see it. If one of you has a clip for it, that'd be amazing. Yeah, the big blonde. That's right. The big blonde one. Yeah. I'm trying to find her. I'm trying to find Ashley Merchant. Ashley Merchant. I don't remember the ponytail guy. In this clip here that I do have, this is after the fact. This is before she makes her argument. This is what I have here. This is where they
this is them. This is them.
But right, I know that's them. But this is after they made their argument. I want to see their argument. That's what I really want to see. So that's what I'm actually trying to put my hands on.
Yeah, their argument is excellent. It's basic, and the judge starts getting all confused. He's thinking he's the god of all law, and there's only one god of law, and that's MLS god of law. Obviously. And but if you're gonna, he thinks he rules. See, there's a criminal and there's a civil contempt, and there's a difference there. And I'm no expert on contempt proceedings, thank God. But obviously, these lawyers are briefed and ready to go because this judge has been out of control. So what the judge is trying to have is he's trying to have the best features of the criminal contempt and the best features of civil contempt without the downsides of either. So like granting the bond or what the maximum fine is, holding somebody in jail, all these things. He's like trying to pick and choose which pieces that he wants. And the defense, these lawyers, Merchant and the other fellow, are saying, is this a criminal contempt proceeding or is this a civil contempt proceeding? And the judge is kind of thrown by that. He doesn't quite understand the distinction. He starts doing quick research and saying, well, Westlaw and head notes say this. He's trying to do it on the fly, but they've got him aced because they know the subject inside and out. And so they probably wrote a book or a chapter on it. And so when he comes back, he says, let me take a break. He takes a break and then he comes back and then issues his double down dumb ruling. But he does give himself a little space for the appellate courts to bail him out. But the appellate courts aren't going to bail him out. The appellate court's going to say you should remove yourself from the case, as far as I'm concerned. But I don't know the Georgia appellate courts. Maybe they're terrible. But, they want to scratch the back of their fellow judges. All right.
I think
that's the context of what we're going to see here.
Great filler, my brother.
Yep.
All right. So
it says it's around 8:30. Yeah. Mama Bear.
Yep.
Yeah, it's right after they come back, right about there, yeah.
Thank you. Appreciate the suggestion. I know I missed a bunch of chats. Quick theory on T-trial. Judge flagging the jury leak could cause mistrial, extending gag order on Trump, preventing him freely campaigning even longer. Judge flagging the jury leak.
All right, so jury.
sure. Oh, you're saying that's why he flagged it? To cause a mistrial? I don't think he wants a mistrial. I don't know. I don't know how this is not a mistrial.
It should be a mistrial.
He is sentenced the next 10 weekends in jail. Yeah. Well, you're gonna see her now. Just go to the full live stream. We got this. Infamous Celia has the full court proceedings. Here's the full stream from today. Includes merchant. Okay.
All right, ladies and gentlemen, please be seated.
Thank you. Thank you all for your help. Appreciate you guys. You're amazing. Tip of the cap. Joe hasn't played the cartoon. Okay, yeah. Hasn't asked the Rumble Ghetto for likes. 2,000 viewing. Missed opportunities. Learn, Joe, learn. Do I got to do everything around here? Grifter? Thank you. I appreciate that. And Barb Loves Alaska says, watch Ashley Merchant take the judge on and Steele retains her. Oh, we're about to watch that right now. I should pause here and let you all know, in case you're wondering, just how close is Joe to 100,000? How close is Joe to 100,000? Well, here's the number right now.
What is it?
98,480.
Come on, we got to go ahead, subscribe.
If I would be most appreciative. This is my episode. You know how many videos I've uploaded so far to YouTube? As this, what number this is, Steve?
No.
999.
Ooh.
My next live is going to be my 1,000th upload. And I said that if I can get to 99,000 before that, I will do a 12-hour stream and try and make a push for 100K during that 12-hour stream. But that means a whole bunch of you gotta not just hit like, but hit the subscribe button. So if you can jump on board, I would be most obliged. I don't know if I'm going to make it, but if I do, I also should mention I am not going to be streaming tomorrow night or the night after. Tuesday night and Wednesday night are Jewish holidays, so I'm not going to be here. So don't go looking for me the next two nights. I do expect to be back on Thursday night. And if, in fact, I see him at 99,000, I will go for 12 hours. So if you're joining late or whatever, you're watching this after the fact, you can help push me forward. I would be most obliged.
See, I always seem like I'm on your streams when we're like, I've got to carry Joe across the line. That's like, I'm always like the hand the ball off. It's like, come on, we're going almost there. Oh, right, push it through.
Yeah, that is part of your function. You're awesome at that. That's your specialty. All right, should we get back in here and
do it
and get Ashley Merchant going?
Yes.
Remember the part in Jurassic Park where the T-Rex eats the attorney on the toilet? Ashley's talking was like that. Ashley's a T-Rex. All right, cool. Here we go.
All right, ladies and gentlemen, jury, how you doing? All right, listen, it's as you can see now, the hour is almost 6 o'clock, and there's some things we had to take up. So we're going to recess for the evening. Okay, so tomorrow morning, 9:30 for an anticipated 10 o'clock start time. All right. Any ministerial inquiry of me? Okay. All right, ladies and gentlemen, let's go through your customary nightly admonitions. Okay. Remember, as you leave here today, not
on this channel,
but remember to leave your notepads in the basket. Do not discuss this case in ones and twos.
You can burn them because you're never going to need them because we're never going to make it all the way to your deliberations.
They're back there as you are in your in your headquarters at your deliberation room, or as you're going back and forth to your homes of residence in our great county. Also resist temptation as well to even as in ones and twos for you to discuss the matter. Remember, I told you that it would be a violation for you to recap or otherwise handicap to office.
No one cares.
All
right. We don't care about that. We don't care about his instructions to a jury. They were expecting he's ultimately going to be disbanded. Kenneth Copeland's like, man, how long am I sitting here? Why is he still sitting there? They'll probably send him out before Ashley Merchant gets in there.
Skip ahead, brother.
Testimony, okay? All I want to know is that
wait, send him out of there.
I'll wait on them to come in.
What does I'm asking you?
Guys check it
because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers.
I didn't call, but
Okay, and I mean, and that's
let me just finish.
Okay.
Because you said to me that you figured out somebody told me this information, and you somehow said that it's privilege, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just.
Or they're not in your courtroom.
We just don't have any. We just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean,
there's no space in this room for more people.
We can let in as many as we possibly can, and we'll fill up our benches at this point in time. That won't violate our security protocols, but that 8H is available. And then
8H then has to have right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's the president.
Okay, all right. Well,
Nice.
we'll let Ms. Merchant in. That's fine.
Ashley Merchant.
Yeah, Ashley Merchant. All right.
I think that this judge being a general
Ms. Merchant, good to see you.
might have some impact on the way he conducts himself.
I have told your client,
Perhaps.
you represent Mr. Steele, is that correct? Yes. For the purposes of the contempt, I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done.
Purge himself of that contempt?
That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt,
just bend the knee, bend the knee, bend the knee.
Yes.
There's no supersedeas bond, there's no appeal, and
That's not
I'm
true.
going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So he can. I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is because of the way this information was disclosed,
who cares?
it is troubling to the court, and it's
Well, it shouldn't be.
since it was a ex parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
Judge, can you come up to the microphone? Sorry.
Please.
Where would you like this?
Microphone, it'll pick up, madam.
Thank you so much. Just for the record, Ashley Merchant.
Which one?
It'll turn green. It'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
And with criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written,
Right.
witness list. We're entitled to present our own witness list.
Right.
No,
Notice of that.
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is.
That's not an answer.
So
That's not correct.
Ms. Merchant, I'm going to disagree with you.
Now you say it's not correct. I do want to pull this up here because he actually wrote his order up. Should we pause before we hear her arguments and hear what his arguments are? Because I have his order here.
That he does at the end. He does this order at the end, not currently, but yes,
Oh,
you can
okay.
go ahead. You can do it. I mean, it's
If he does it at the end, then I'll save it. I'll save it for the end. But fine, we'll pull up we'll pull up. We'll let her go first. Then.
Well,
So
and
it's kinda
Judge,
like-
just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it
Right.
has to be referred to another judge.
Right.
Doesn't require recusal. You actually have to sua sponte, send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is
'cause
Henry McClarty. It's
Boom.
399, and it says that is one of the cases. Also, two other cases: Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would think.
Oh, this is great. I wanted to do this, Joe. Joe, you're great.
372.
Okay.
Also 215 Georgia App 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those. You have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding. So
Right, exactly. Unfortunately, I'd say fortunately. Yeah, this is a big shotgun blast. This is not.
I do have other.
Why is he bringing the hammer down on this guy? It's ridiculous. You know, he's not doing anything wrong. The judge is what's doing wrong. He just doesn't like it. This is such an abuse of power.
And Judge, I'm not the only one here.
I'm trying to see where
There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I've had space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns
I'm not
as
seeing.
well.
I just want to point out. I'm not.
You know what else is old?
I'm
is
not
that,
seeing it in McClarty. At least I didn't look at Adams.
You know what else is difficult?
I'm not seeing where the judge has to turn it over to another judge.
Well, but see, if it's direct criminal, it is. I think now, of course, Georgia's its own deal, so I don't know. But you know, you're talking. How is it that the judge, who is a witness, can say you are a criminal without witnesses, the right to confront, without the right to counsel, without the right to hearing, without being notified of your charges, and the right to confront your witnesses against you, which is the judge himself. So, you know, it's, you know, like that's 94. That's really old. Well, so is the U.S. Constitution. That's really old. What's that have to do with anything?
This is In Re Hasty here. I'm pulling up for you all. So I'm trying to find where she's correct, where her claim is.
Can you put it in private chat and I'll look at it and you can go ahead with the thing?
Yeah, I'll do that right now. That's a good idea. That's a very good idea. You tell me if because she's claiming that this is indicative.
Yeah, put the sites and I'll look them up real quick and then you can do your show.
I found the right In Re Hasty there, but and I didn't find the Adams one that she referenced.
And they can go to 8H and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their names.
They still would have to be searched and still would have to be subject to the court's protocol.
Really?
And also, there's room in the jury box,
there?
and then there's room in the courtroom. So we would ask that they be allowed
I
to.
don't want them in my jury box, okay? No.
I understand.
Wow. You smelling the fear? Are you smelling the fear? How we end up in a system where judges have so much power? How we correct this balance power? It's difficult to come up. This requires an overhaul of our judicial system to stop this.
May one additional attorney
Because they do need latitude.
come in, then Alex Susser. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
Yeah, I certainly may, sure.
Great. Alex Susser?
Yeah. Okay. So what you want to go to that case?
Thank you, Judge.
Which case? Hasty?
Yeah. So if you go to In Re Hasty.
Yeah.
Okay. So the first part of that, there's talking about outrageous behavior. So according to Hasty, he continued to parry the blah, 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 blah. Okay. So there's that. Okay, so you look on that 350 on appeal, Hasty argues. Can you see that? Go down. On appeal, Hasty argues, right? He says, the Hasty argues the trial court erred in finding him in contempt and failing to allow him a hearing. He contends that the evidence was not sufficient to support a finding of criminal contempt. Now, then it says, although we do not address the evidence, they say he should have been given a separate hearing on the matter. Okay, you see there? So he should have been given a separate hearing on direct criminal contempt. Now he says there's an exception to that, and that is if it's something that tends to scandalize, it's in the presence of court and tends to scandalize it and hinder or obstruct the orderly process of the administration of justice and the preservation of order and decorum in the court, then you don't need to do that. But in this case, this attorney was not doing that. There is nothing he's doing that's disrupting the order and decorum of the court. So therefore, his conduct was not of the type that must be dealt with summarily. Consequently, we believe that the appropriate method for handling this matter is to provide Hasty with a separate hearing, which is what she's saying. Additionally, we hold that the trial judge should disqualify himself from officiating over any further proceedings in this matter. Judges should disqualify themselves in proceedings in which their impartiality might be reasonably questioned, including but not limited to instances where the judge is to the judge's knowledge likely to be a material witness, which is in this case.
So that's what she's saying, that the judge should disqualify himself. Now, I'll tell you, the exception that they reference here of it's true that direct summary proceeding which arises in present court and tends to scandalize it and or hinder or obstruct the orderly process of the administration of justice, preservation of order and decorum of the court is exempt from the due process requirements and notice of hearing. So I'm just going to point out, in his order, he claims that that's exactly what this is.
That's because that's why he took an hour and a half to write the order, because he read that case.
He tries to find shelter that way.
He's trying to find shelter, but that's freaking garbage. That's a lie, and this judge is a liar.
Yeah,
because that's not what this attorney was not doing. That he was very professional. He was citing case law. He was representing his client, and that is a garbage lie. And so this is what happens when lies get infused into our court to justify actions.
Well, let's come back to where was I over here? Oh, come on.
I mean, you guys watched it. We watched it on the stream. Was that lawyer disrupting the courtroom?
Or obstructing justice.
Obstructing justice?
Obstructing justice by refusing to give the name. I mean, unless then it sort of falls on him to explain why he really needs that name so much. And no one understands that. He doesn't really explain why that's such, that we got word salad from the DA and trying to justify the judge's craziness. But it's hard to understand how that's obstructing justice that without the name, he can't go forward. I just got to pull this up real quick here. Chag Sameach, thank you so much. That's Hebrew for happy holidays. I appreciate that. I'm not sure what Todd means by this. Son's Day will show in capital murder. They think they're wrong judge 2% of the time. DA 4% of the time. Convicted 11%. I'm not sure what this means.
Okay, hold on a second. Son's data. Oh, this is Todd Larson, who's doing the PhD thesis that he's talking about on the sociology project on the Capitol, and so he's showing that the data will show capital murder. They think they are wrong. So this is when do the judges think that? Does the judge think he's wrong? The judges never think they're wrong. 2% of the time do they think they're wrong. DA prosecutors only 4% of the time do they think they're wrong. Convicted people say 11%. So the accuracy, so this is interesting. So I would like you to communicate with me about this research. This is fascinating stuff. So he's saying that his PhD fellow, I think it was his son who is in a sociology program, that it was inspired by Ghazni books, is talking about the confidence level of the different parties. Interesting.
All right. Not a snitch. You're out of order. This whole trial's out of order.
Whole trial's out of order.
Criminal intention is guilty. Why the judge so inarticulate? I don't know. I don't know what the story is. Expanding an orderly process, also same for disorderly. Yeah, well, that's what he's desperately trying to do in order to give cover to himself. But let's go forward here.
Henry Adams, it has two issues. One is the motion for disqualification. Okay.
There's this guy. He's good too. See, these are specialists.
I've
I
seen
love
him before. This guy.
And I think the judge
I
went
think he was. I think he was.
things that caused that.
I think he was in that
caused
trial
that issue
with that
presented. So
self-defense. That
I'm
Aubrey
gonna
guy.
take a look at the other case. That was in
Georgia, the one that was going on at the same time as
Georgia,
Rittenhouse.
372. I'm
Yes.
looking at
The
other case.
jogger who was killed.
And there's several others when you're ready.
Well, we'll skip past him reading. More reading.
Hasty's conduct didn't rise to a level that necessitates warrant summary contempt by the court. That's the difference with Hasty than in this particular case. So
And
I distinguish your two cases that you've given me thus far.
oh, those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus State, it's 279, Georgia 13, 2005. It also
You said 279 Georgia what? I'm sorry.
Georgia 13.
Georgia 13.
It's a 2005 case,
All right.
and it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
Amen. Imagine what we would have seen with Merchan. Imagine what we would have seen.
See, but you all are covering under. Let me see.
I'm sorry, Judge.
Hold on. Just a second. Pardon me.
Notice how she's being so polite. It's a very important thing that you keep your cool in these moments. It's really important. It's much more challenging than you'd imagine.
Yeah. Well, I gotta say that's maybe one of my flaws. I get very aggressive in these situations, and I know how to win friends and influence people. Right.
I learned that in law school when I was applying for moot court. I gave two arguments, and the critique I had on the first one is that the panel felt like I was going to bite their heads off, and I took that to heart. And the second one through, I was just as polite as imaginable, while still being like very aggressive on behalf of my position. And it happened to be the head of moot court who was sitting on the panel, and he said it was easily the best argument he'd seen throughout the entire competition. It's actually a pretty funny story how I got in because my papers abysmal, but they put me on because he happened to be sitting for my moot court argument. It was abysmal because I had a random.
Contempt is directed. Trial court has the power after conforting the contemptor to opportunity to speak in his own behalf, announce punishment summarily and without further notice of hearing. I already did that, Mr. Steele. He's already told me. I already gave him the opportunity to do that. So we had that conversation this morning already. So.
And Judge, there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have one. So The question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial.
Right.
So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people, and as to how that information was disclosed. That's a real problem.
This is total abuse of discretion by the judge.
Total wrong.
This is just it's asinine what he's saying here.
I can't even believe this.
It's such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does.
So then you don't have the right to start drilling him and making that the obstruction now. Let's assume he never asked him that question, so then it wouldn't be an obstruction. It's only because he's asking him and demanding under threat of throwing him in prison. That's what's making it the obstruction. You're creating this situation by putting the gun to his head that way. It's not him making the obstruction. You're doing that, Judge.
I'm not saying anything, but you know, but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree.
Well,
I believe that.
Yes, I love it. She's great.
The court has put him in that position.
No.
Yes.
He cannot be held in the law states, McClarity, which
I say exactly what she just said.
cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder, obstruct the orderly process of the administration of justice. The preservation of order and decorum in the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merton, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping.
Nice.
That is a crime. He has a Fifth Amendment privilege against answering those.
Right on, boy. She's great.
This protects all confidential information that is gained, not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of them by nature.
Okay, well,
you have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped.
Oh,
you're alleging that.
You're alleging that. Oh my God.
Who says he did? You're alleging that. Who says he did?
What if the prosecutor accidentally emailed something and it was accidentally CC'd? Was that improper? The prosecutor disclosed it accidentally. They didn't intend to. They should have, but they did. Is that improper? No.
I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my
call. It's not his call as to the information. What is the basis of that? What is the legal basis for that? What's the jurisdiction for where's the case law say that there's a scenario where you can withhold from him that you're having an ex parte communication, that now it's wrongful for him to have that information?
Really, at this point in time, I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness.
Right.
This is like when Marcellus Wallace said, "I ain't done with you by a damn sight."
This is a case in point. This is a case study on terrible judging arrogance.
Yeah, it's hubris. That's exactly what it is. That's what I was thinking. Hubris.
Necessarily, it cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge.
This is easy. This is not complicated.
And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
Right. She's right.
Everything.
Perfect.
I'll let the appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
If he had a brain, as far as like trying to salvage this case at this point, trying to salvage it and hoping that he can overcome the misconduct that he engaged in by engaging in the ex parte conference in the first place, assuming he could find somebody to get past this. If he wants to proceed with this trial, he has to suspend this decision of contempt until it's reviewed by an appellate court. That way, you have this attorney there, and you don't run further afoul by depriving the defendant in this case from having the counsel of his choice. No? So, I mean,
no. Well, I think it's a mistrial. Now the question is I mean, well, I don't know how good the Georgia bar is generally. Obviously, Fulton County has got major problems. But if Georgia bar has got some cojones, this judge should be removed.
Yeah.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will say for the record at this point in time that Mr. Steele has in fact,
Now, I just want to pause for a moment. If you are an appellate court here, you recognize that they're 88 days into this trial, right? You certainly don't want to have to make them start all over again and get another 4 months worth of trial, because 88 days of trial takes 4 months to do, because it's like 20 days in a month besides if you take out weekends and holidays. So you don't want to have to redo 4 months of trial. If you were trying to salvage this case and you're sitting there in the appellate court and you're trying to be fair and you're trying to salvage this case from having a mistrial, what would you, as an appellate judge, determine to try and maintain jurisprudence here without necessitating a brand new trial?
I don't think you can. I don't think you can save the trial at this point.
What if
the judge needs to be disqualified?
Okay, what if they disqualify the judge?
You can't bring.
I'll try and come up with the remedy that the prosecutor may try and come up with to say, okay, look, don't make us start all over again. For the love of God, don't make us start all over again. So what if you're the prosecutor, if you're Fani Willis here, right, and you don't want it to start all over again, and you smell that the writing on the wall that this thing is going down in flames because of what happened today, and you're trying to save it, you're trying to save this case, would you not urge the appellate court, say, look, change judges on us, just like as if, something medically happened to this judge. Sometimes that happens in a lengthy trial, especially. So give us a new judge, let them have the transcript, strike the testimony if you have to of this one witness altogether, and let them have the transcript so they can see everything that happened. And in that sense, try to remedy the situation so that you don't have to start 4 months all over again. Do you think that if they struck all the testimony from this witness, shared with them the transcript of everything that happened, and change judges, that you can stop this from being a mistrial?
Well, the last one is the one that I think is the problematic one, is the change of judge in the midstream. I don't think you can remove the judge with this non-disclosure issue, ex parte witness tampering behind the scenes. I don't think that you can switch judges at this point and have a fair trial. I don't think so, but maybe they can. Maybe all those things done together would amount to, we can continue this trial. But it kind of reminds me of like when they said the company is too big to fail. So our taxpayer, mom and pop, has to bail out big corporation because they're too big to fail. I think if a trial is too big to fail, it's too big. And this is the point. They should have broken up into little pieces. This was the mistake that the prosecutor's office made by making this huge cosmic justice trial on getting all the young thugs in one trial, and we're going to put them all away, and having it last for a year. That's a mistake, because you're going to run into tremendous.
This will happen again. This will happen again. Some other problem will happen.
Right. So break it up into
Next trial.
one trial. You know, each defendant has their own trial, and it's clean. And go for the biggest charge. Don't get like 50,000 charges. Go for the top 2 or 3 charges and nail them to the wall, right? If you want to do it.
And just to be clear, I think that there should be a mistrial here. I don't think that this is remediable, something like that.
Right, I get it.
But I don't think this can be remediated. But if you're Fani Willis, you're trying to find some way to not start this whole thing all over again. And I think that perhaps you try to make that, if you're smelling that this is going down in flames, I think that's how you try to salvage this thing.
Well, but you're acting like a cool-headed lawyer, and I don't see that these people are competent, cool-headed, or anything but arrogant.
And that arrogance, I think, is another reason that this thing is more likely to go down in flames, because they won't offer that. They won't ask the appellate court to do that. They'll just be like, he's right, he's right, he's right, he's right.
Yeah, they just think that it's like, oh, there's no problems here. It's the defense is crazy over there. I mean, it's just complete tunnel vision.
Yeah. Okay, so let's go forward.
Has filed, and I will note this as part for the record in this case.
Check private chat.
Filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
You don't get a superseded bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
just the case law on that is in Ray Hughes.
Hold on.
These guys are. I love it. God bless these guys, right? You know, thank God for these defense attorneys. This is ridiculous. I mean, this is really fired me up. I'm telling you.
It is unbelievable.
Unbelievable. I haven't seen anything this bad. I don't think ever. This might be one of the worst displays of judicial arrogance I've ever witnessed.
Requirement does not apply in the contempt in the presence of the court during the progress of a proceeding. OCGA 5-6-13 Bravo. So you don't get a supersedious on that.
Ha. I get to win. I win everything. I have all the power. You can't check me. That's what he's saying.
So Judge, just to clarify.
Oh, listen to this.
Your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, and that's the reason I'm asking is because the N. Ray Hughes case, which is the 2009 Court of Appeals case 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that in fact is, I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Which is, I think I'm addressing a slightly different point of law.
It is. Hold on.
And it sounds very hyper technical what they're asking about, and the reason they're asking about is because there are, whether it's a civil contempt, an indirect civil contempt, criminal contempt, is because there are different procedures which apply for each of these and different scenarios where they apply, and depending on which poison the judge picks, that sets the guidelines for what he has to do with respect before he can issue an order in the scenarios. And we actually see that he, in his order of contempt, that he's about to start drafting. And I'll pull that up before we get to the next part, that he does everything he can to try and cover his own butt on how he handled this thing.
One is it's Untema. It's a UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the differences between the types of contempt. And then there's another case that I'd invite your attention to, and that is Henry Syverson. It's SYVERTSON, and that is 368 Georgia Appeals, Georgia App, I should say, 865. Right. And that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other,
I'm not going to grant him supersedious.
And so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies. No, criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Sentence him now.
Well, his contempt is as long as he, when he tells me what the basis of the conversation was, who, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
And that's respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt. And that is, you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical.
Yes, you did.
Yes, you did.
I know what
yes, you did.
What the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who.
What's your source for that?
The person.
And
because okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out. I'm gonna think about it.
Yeah, this is where he takes an hour and a half.
All right.
He takes 5. I'm going to think about it for 5 minutes. He is so screwed. This judge.
Yeah, he knows it also. That's why he wrote out this lengthy order. I'm going to pull up the order here. So this is the order. Let me see if I can get this bigger. Oh, that's not going to work.
That's what she said.
Appreciate that. Thank you so much.
All right. Trying to uplift the conversation.
Save image as content. Okay. During the proceedings,
a little bit more.
During the proceedings in the above style case in the afternoon, June 10, 2024, one of the two representatives for Jeffrey Williams, Mr. Brian Steele, took to the podium and stated to the court that he had been informed of an ex parte communication which took place in the court's chambers that morning. The only parties present for this ex parte matter were the court's official court reporter, representatives from the state witness, Mr. Kenneth Copeland, and counsel for Mr.
I mean, look at that. He's laying it out right there.
Yeah.
Go ahead and remove me from the bench. That's what he's saying. I'm saying in my order, I'm admitting that I did this.
In addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication the court found troubling, meaning he got it right. The court, having told Mr. Steele multiple times he needs to tell the court how he came into the information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court feels Mr. Steele has repeatedly refused to follow the court's order. Every court has the power to compel obedience to its orders and to control the conduct of persons connected with a judicial proceeding. One who disobeys an order of command of the court may be found in contempt, citing In re Syverston. One who disobeys, okay. And he cites 15.
This guy, he's a general. He thinks that like everybody has to follow his orders.
Before a person may be held in contempt for, I gotta go to the next page. Do a quick download. Save image as contempt.
This is real lawyering right here, man. You see the Joe, good logic, real lawyering in the.
Violating a court order, they should inform him in definite terms as to the duties thereby imposed upon him, and the command must therefore be expressed rather than implied. The question of whether contempt has occurred is for a trial court, and its determination will be overturned only if there's been a gross abuse of discretion, which there almost certainly has been. There has been a gross. It's been an obnoxious abuse of discretion. Once an act has been determined to constitute contempt of court, the action the court takes to deal with the contempt determines whether contempt is deemed criminal contempt or civil contempt. The distinction between criminal and civil contempt is that criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority to punish disobedience of orders, meaning it cannot be purged, as Ashley Merchant said.
Right.
So you can't fix it. You can't say it's criminal contempt and you can fix this. Because criminal contempt is, you did this in the past. We're punishing you for what you did.
Well, like it's like it would be like throwing a shoe at the judge. Okay, that would be criminal contempt. I'm angry. Here, judge, right? And you threw the shoe. Now you can't purge that because it's done and over with, and you're saying you were disobeying the decorum of the court, and I'm holding you in criminal contempt. But he's saying, I want you to answer a question. I want you to obey my order, and I'm holding a sanction over you until you comply. That's civil contempt.
Direct summary criminal contempt, which arises in the presence of the court, intends to scandalize it and hinder or obstruct the orderly processes of the administration of justice. The preservation of order and decorum of the court is exempt from the due process requirements and notice and hearing. This
is not that. We do not have that in this case. I know the judge wants to say that's what it is because it's mouthing words and pretending like that's what it is, but that is BS. That is not what's going on here. This defense attorney was professional, presenting a motion to defend his clients, to preserve his clients' rights, and that is not obstructing or hindering justice. Only if you define the judge's absolute ego and will as justice can that even be remotely true.
And this is the point that, and this is the key point I want you to take away from this, that you're unlikely to hear elsewhere. Because it's a key moment that happened when Ashley Merchant was talking to the judge, which is who's causing this obstruction. Because let's understand what happens here. There's this meeting, this ex parte meeting. Then the lawyer comes and says this ex parte meeting we think was inappropriate and we should have been informed. We should have been there. It never should have happened. And we need to know what happened there. We're looking for a mistrial for that. At this point in time, what has he done? Has he done anything at all to obstruct justice? No, absolutely not. He's done nothing to obstruct justice. So with respect to the justice of this actual trial, he's done everything he's supposed to do as defense counsel. Now we come to a new moment where after he raises that motion, the judge puts him in a spot and says, well, since you just made that motion, I'm going to punish you by saying, now that you have this information, I need to know who your source is. Now, whether the source is a proper leak or improper leak, let's put that aside for a second. What justice is he trying to protect from being obstructed? Because until he asks him that question, there is no issue with respect to justice being obstructed. It's this new thing that the judge is introducing, where he's like, I've got to conduct this investigation to try fixing this leak. That's a new thing that the judge is now creating it. Now, which is unrelated to the trial, the actual trial itself, the underlying trial. Now it's a new problem that's arisen, which really only arose because of the judge's improper actions of having this hearing. This never happens at all until the judge now does this thing, which is a violation of case law, because we have the case of Scudder, which says the judge is not allowed to have this. There's a default position. The judge is not allowed to have meetings with a witness, with ex parte, with only one party there. So now the judge first does this wrong thing, violation of case law. Then the attorney properly brings this application, properly brings this motion saying that violation that you did this morning, that's grounds for mistrial. I need to know a heck of a lot more about what happened. Now, at this point, everything is totally fine. There's no obstruction of justice. The obstruction of justice only comes about because the judge starts putting a gun to the head of the attorney saying, I now need to go on this new tangent of plugging a leak and trying to figure out how you got this information. That is, you cannot now say that there's obstruction of justice when you're trying to start a brand new investigation and you're considering this attorney a source, which is what makes him a source. He's a source because he ended up falling in his lap. He admitted that he didn't think this guy was the one who's the leak. He admitted he didn't think he'd engaged in eavesdropping, that was a bogus claim that he threw at this attorney. They're like, well, maybe you eavesdropped or else you had some other improper source. Well, first of all, that's a ridiculous conclusion by the court. There's not founded on anything that there's an improper source rather than some, as Steve pointed out, some erroneous job, some clerical error from the DA's office or countless other ways that Brian Steele could have learned of this meeting. Maybe he observed them coming out and talking as they came out and saying things that they shouldn't be saying. There's 1,000 different ways that he could have learned of this, which would not be in any way improper. But the judge came to this conclusion and said, I'm going to go off on this tangent. And because I deem you to be a source to help me uncover this whole thing, and you're not enabling me to go further in this tangent investigation unrelated to the trial of these defendants for RICO charges, I'm now making you a pivotal piece. And if you're failing to turn that over, you're obstructing justice. It's justice that's unrelated to the RICO trial. It's justice into the problems that he judges to be within his own secret cabal there, which is conducting improper ex parte meetings and conferences with a witness in violation of law. That is complete abuse of discretion. And that is why I cannot fathom that the court is going to say, oh, yeah, you did fine here, Judge. Everything here is completely above board. And that is why when he tracks this language here, he's tracking this language of saying that this is the whole processes and administration of justice and all that other BS. The reason he's doing that is because he's trying to fit within the case law, which says that if we're trying to go through to stop the obstruction of justice, then you don't have to go. Then you don't have to go through the normal procedure to have someone held in criminal contempt. But he's using this bogus, transparently stupid argument of obstruction of justice because he's trying to circumvent the steps that he procedurally had to take in order to have him held in criminal contempt. And that is why this is so gross. Not only is it gross what he did this morning, but now his desperate efforts to try and put him on the spot was completely inappropriate, abuse of discretion. And now he's trying to cover his tracks for how much he screwed up by pretending that this is an obstruction of justice.
I'll tell you, I think we've had 2 authentic Joe rants in one stream. This is bonus material. You got to say we're in the bonus round. Well said.
Thank you. Thank you. Whew. All right, so let's get to the end part here of where he gives his final adjudication on this whole stupidity. Where was it? Where were you? Over here. There it is. Oh, that's where we're at. Look at that.
Hey, thank you. Whoa, look at that. Go.
Look at that.
Go.
Hey, 500.
Go. Woo, look at it go.
Dang.
Hey,
Dang.
baby. I feel like I'm in Las Vegas, baby.
Ding, 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 ding,
Get
ding. All right.
Oh,
If
thank
you
you.
haven't hit that button yet, the subscribe button, I'm working my way to 100. You'll be able to say, look, when I hit 1 million, you'll be able to say I was one of the first 100,000. It's a very limited window of time for you to be able to do that. Just saying. Just saying. Let's skip forward now to where he finally comes out after the fact.
Okay.
President, the court's had an opportunity to reflect, and Mr. Steele, if I could ask you to take the podium, please, as well, and stand next to your attorneys. Okay, Ms. Merchant, Mr. Steele, and I apologize.
Mr. Susar, Judge.
One more time?
Susar.
What, spell your last name for us?
SUSOR, Sierra, Uniform, Sierra, Oscar.
You're a good man. Good man. Okay, all right. Okay. All right. Thank you, sir. Okay, Mr. Susar.
Oh, he's so friendly now. Such a kind attorney.
Or to the order of contempt. Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed. And you may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, sir, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay.
Now the reason he gave him weekends was because he wanted such a base move, such a like this dude. He's like cementing himself in like legendary status for criminal defense attorneys, saying, "Throw me in prison with my client."
Put me in jail so I can work on my case with my client in his jail cell. I love it, man. That is balls to the wall.
And the one thing the judge realized is like, I can't have this guy go forward without having his attorney there. Like he's like, that's just begging. That's begging the appellate court to punch me in the face.
Yes, and also the fact that it's not until Friday begins Friday, right? It's not tonight. It's not spend the night. It's like because he knows the appellate court's going to shut him down.
Yeah, probably.
All right. Okay.
Is that it?
Yeah, that's pretty much the end of it. That was awesome, man. I'll tell you what,
counsels, I'm done with this. Unless you have anything else. All right. Thank you, Miss. Thank you, Miss Merchant and Mr. Susser.
Thank you.
Okay. All right.
Wow. So let me just pull up. Let me pull a super chest. Then I'm going to take a quick look at his appeal that he already filed.
I love it. That's so great.
If prosecutor asks for dismissal without prejudice, would double jeopardy apply at this point? No.
Well, wait. What do you mean no?
Well, first they wouldn't ask for a dismissal. They would say they would join in moving for a mistrial.
No. It's if they would be if the prosecutor dismissed it, jeopardy's attached.
He's not dismissing. He's not dismissing.
I know.
I know he's saying dismissal, but I'm saying is they would join in. If anything, they would join in a motion for a mistrial.
Yeah. Okay.
They wouldn't ask for dismissal. And a mistrial, there would be no double jeopardy attaching.
No, but I don't know about that. Because the prosecutor was in on the deal, the ex parte communication. And if the prosecutor initiates it, then double jeopardy could apply. It's difficult, but it's possible.
Interesting.
Yeah.
I would consider that. Thank you, brother.
Mm-hmm.
Counting 12 on screen 3 at the table equals 15 DEA. Steve, you missed the good Lawgic players. We had the New York Trump case. If you say this is the worst judicial arrogance, yeah, she was part of that actually. So did a great job. My bad. 4 white on monitor. 15 plus 3 equals 18 DA staff. Can Steele sue for time in jail for contempt or seek compensation from corrupt, ignorant judge?
Steele. That's so impossible. It's the system is so geared. What we need to start doing, this judge should be removed. That's my solution. Because judges, how else do you get it through to them?
I don't think it started with corruption. I think it started with incompetence from the judge and having that meeting in the first place, and then we just saw the hubris of the judge basically just force him to double and triple and quadruple down on it. So his embarrassment took over. So instead of owning it, he basically just became an even bigger clown. What are sanctions on prosecution for the part of the ex parte hearing without notice defense?
Well, it's a Brady violation, and that's a very good question. There should be bar sanctions for prosecutors who violate Brady. Very rarely are prosecutors held to any kind of standard. And mainly a lot of it's because the defense bar doesn't report it because they have future cases they don't want to jeopardize. And prosecutors can be very vindictive against defense attorneys that report them to the bar.
This kind of DA office has real issues of corruption, like listening to you and Steve. Thank you.
Thank you.
I appreciate that. You cannot compel attorney to testify against his client. Yeah, well, that's
the point. Why doesn't the judge understand that? That's so simple.
The witness could be a source of their counsel. Are they restricted in any way?
The witness could be the source or their counsel. In what way is that conversation confidential?
I have no idea.
The sacrosanct chambers. His chambers aren't sacrosanct. It's just a freaking government office building.
Oh, good. I'm glad progress is going well. Thank God. Joe, if you continue to follow this trial, I promise you blow past 100K. You're probably right. And I'll tell you, if I didn't have Jewish holidays starting like tomorrow night, I probably would jump right on this right now. But I'm going to definitely think about getting on this next week. Joe, we all love you, and Steve just sweetens the pot.
Oh, thank you. That's sweet.
And Lethal Old Fart says, after watching this judge attempt to coerce and impose his will on this attorney, I'm absolutely convinced this is exactly what happened in the private meeting, and the story relayed was absolutely correct. 100%.
100%. I agree.
100%.
Yes.
What box zero did the judge get his law license from? I think he really screwed up this morning.
When I looked at his resume, I think it was on Sean Potentially Criminal's show. You wouldn't know. I mean, he looks pretty impressive. His credentials are pretty impressive, just from a raw looking at it. I mean, he's a UGA guy, but what do I know? He's a general, and he's got all these things and credentials.
Yeah, I'm actually saving now so I can open them up in a picture format. I didn't mean to do that. Go back. If I go to, I need like another minute to save the images here so we can look at his motion 2. There's 4 pictures I got to screen save real fast here. So this is motion 3. And save, and then go to motion 4. Save images, motion 4. Okay. So he's got like on the 4.5 page motion, which is double space, so it shouldn't take us that long to run through this real quick. Why don't I have motion 1? I don't know what happened there. Save images. I do have it. Okay, so it's open. All right, so let's the motion.
Todd Larson, you got to talk to me because I know something about PhDs. So be careful with those PhDs. Make sure to confine the data set so that you can finish it.
What's my Venmo account? I always forget which one it is. I think it's in the description. It should be in the description. Is it in the description? Show more. Yeah, it is. It's venmo.com/good logic is my Venmo. And it's down. You can click a link in the description. And thank you so much. You're awesome. Allegan saying it likely started prosecutors saying they believe witness intimidation was occurring from defendants and their counsel, so crime fraud excludes them from the meeting. Perhaps, I don't know. I'm not sure.
From defendants, but the defendants aren't in the meeting. Only the defense attorneys.
No, but he's saying that maybe they tried keeping him out and they convinced the judge to keep him out by saying that there was witness intimidation. So that's why we can't have him in here. But yeah, you would think the judge would have said that, right? My son's data wants to make a standard, but he's already getting some pressure from the digits.
Yeah, this is the fellow that's got the PS. Yeah. I was saying, there's a make sure that to make that, there's a lot of I got a lot of suggestions on your PhD thing, but anyway.
Yeah, you should reach out to Steve. I'm sure he'd love to talk with you more about it. All right, comes now Brian Steele movement. Herein and hereby files this motion to set aside contempt in the above referenced case and support this motion. Movement shows as follows. Movement is counsel of record for Jeffrey Williams in indictment number, etc. in Fulton County. Jury commenced trial on January 4th, 2023. Look at that. So it's going on for 5 months. I said 4 months. It's going on for 5 months.
This
Today,
is a disaster.
On June 10, 2024, the court set us, along with state prosecutors, engaged in an ex parte hearing with sworn witnesses, with a sworn witness for whom an order of immunity was issued. The witness had previously asserted his Fifth Amendment privilege and was held in contempt. The court and the state admitted on televised court proceedings that this meeting took place. Attorney for defendant Jeffrey Williams, Brian Steele, commenced proceedings in open court on June 10th by disclosing that defense had knowledge of this information, demanded the same, and proceeded to make a motion for mistrial.
Clean. I love it. Very well done.
So far, so good. Let me get to the next part.
This is not really the appeal. This is a what is it?
This is a motion. This is a motion which they know that he's going to deny. This is a motion to him. All right.
I don't think it's. Well, we'll see who it's directed to.
Well, let's go back. We'll see.
Motion to set aside contempt. Judge Glanville.
Yeah, it says.
Okay, so it's in his court. Yeah,
it is in his court. They know he's going to reject it, but then they're going to appeal from his rejection.
Exactly.
It's a formal motion that they thereby have a further record to appeal from. The trial court immediately inquired of Mr. Steele how he came in possession of the information, expressed outrage that Mr. Steele knew of this information. Citing State of Georgia Bar Rule 1.6 confidentiality of information, Mr. Steele declined to provide the information. It provides in pertinent part as follows. A lawyer shall maintain in confidence all information gained in the professional relationship with the client, including information which the client has requested to be held inviolate or the disclosure which would be embarrassing or would likely be detrimental to the client unless the client gives informed consent, except for disclosures that are impliedly authorized in order to carry out the representation or required by these rules of law or by rule of courts. Comment 5, so the rule says, the principle of confidentiality is given effect in two related bodies, and they highlight, we're going to focus on the bolded part. The attorney-client privilege applies in judicial and other proceedings. in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from the lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence, but by the client, but also to all information gained in the professional relationship, whatever its source.
Yeah, see,
The
there
lawyer
that's
may not disclose such information except as authorized or required by the Georgia Rules of Professional Conduct or other law. And he would say this is other law. It's like a directive from the court is other law. That's what Judge Glanville would likely claim. But you know, the propriety of that law remains in question. Moving on to the next page of this motion. The court repeatedly demanded that Mr. Steele reveal the source of this information, claiming that the way that Mr. Steele obtained information was unlawful. Mr. Steele relied on Rule 1.6 and declined to provide the source of information, which was never alleged to be deemed confidential by any court order, placed under seal or subject to protective order.
Another great point that we didn't talk about. Generally, if the state wants to do so, they have to move for protective order, which it says it's not placed under seal. It's not.
So what makes it private? What makes it proprietary?
What makes it private? Yes. Why is this private? Sacrosanct judge chambers. It's a government issued office. You're a state employee. There's no holiness. It's not the temple.
There's your abuse of discretion right there. The court held Mr. Steele in criminal contempt for refusal to provide information in order that he be taken into custody. The court temporarily permitted Mr. Steele to participate in trial for the day, but has indicated that at the close of business, it will again address the matter and demand that Mr. Steele reveal from where the information was obtained. Based upon information belief, Mr. Steele will decline to disclose this information. Hours after holding Mr. Steele in criminal contempt, the court stated that Mr. Steele can only purge himself of the contempt by telling the court from where he got information he shouldn't have. He, quote, shouldn't have information that he shouldn't have had. And finally, wait, did I miss something here? Sorry, I skipped a part here. Thus, the court has imposed an illegal and inherently inconsistent punishment for this criminal contempt because it has to be a set amount of time that cannot be purged of its criminal contempt. Moreover, the court has involved itself in these proceedings, and thus the court must recuse and allow these proceedings to be handled by a separate court. Where the announcement of punishment is delayed, and where the contumacious conduct, that's like the improper conduct, was directed toward the judge, or where the judge reacted to the contumacious conduct in such manner as to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. Citing In Re's Schoolcraft. He's like, I want a more recent case. Here's a 2024 case for you, Judge. That's funny. The court has stated that this is criminal contempt, but has not afforded Mr. Steele due process, including the right and to notice and to be heard. The court has refused to issue a written order of contempt, stating that this is a criminal contempt.
That has been that's been remedied. So this was written during the pendency of the trial before he issued his written ruling.
Right. Mr. Steele's statements are not interfere with or pose an imminent threat or interfering with the administration of justice. And they knew where he was going to go.
Right. That's right. There it is.
An attorney may be held in contempt for statements made during courtroom proceedings only if the court has found, one, that the attorney's statements and attending conduct either actually interfere with or pose an imminent threat of interfering with the administration of justice, and two, which we don't have that here, right? It's not that his statements did it, it's that he's refusing to answer. And two, that the attorney knew or should have known that the statement's intended conduct exceeded the outermost bounds of permissible advocacy, which there's not even a claim of that. Because contempt is a crime, the evidence must, of course, support these findings beyond a reasonable doubt. To the extent that this court believes the contempt is civil, there must be a clear and unequivocal order of the court that Mr. Steele is deemed to violate that needs to be addressed and remedied. It certainly cannot be the law that every time a judge asks a question, the failure to answer lands you in jail. Especially when counsel
lands you in jai.
Yeah, well, they did this fast, so I will give him a pass. Especially when counsel has a colorable basis for declining to answer, like Rule 1.6.
Right, exactly. This is good done.
Move and request that this court can reconsider, rescind the order of contempt. Alternatively, this court should immediately grant Mr. Steele a supersedeas bond.
So this was before the court, and he denied this in front of those attorneys. So the other two attorneys came up. So this was denied at that sentencing. So
Yeah.
he's just plunging ahead. To hell with his rights. He's holding him in. He's charged him with a crime, a misdemeanor crime. Did not give him a hearing. Didn't give him notice of the charges. There was no third-party judge. There was nothing. He just said, "You're a criminal, and I'm the judge, and I can make you a criminal just by my say-so.
Right.
You're not entitled to any rights, any lawyers, no hearing, nothing."
And try to squeeze into some exception for that hearing with that bogus issue that I explained why it was bogus in my last rant, which was like roughly 15 minutes ago. So
Yeah, I think the judge, this could get him off the bench.
This was terrible.
It was really, really bad. This was really, really bad. And I don't know.
Yeah, Todd Lars. So we got this uncovered 80s vault says Joe and Steve Karen Reed trial proctor cross exam started today, goes full next session. Yeah, I don't think I know everyone's making rain off of the Karen Reed trial. I don't expect to jump in on that. I haven't been watching anything. I've been packing. You see, if I start doing this trial, I'm going to be doing this, spend the next year of my life just covering this thing, like literally a year of my life.
This is so cool because it's a little nugget. It's all encapsulated in one day. You did a great job. This was a good stream.
It was all you, brother. I just got here. What in the crap show is going on here?
Exactly.
Is that Ashley Merchant? Yes, it was Ashley Merchant. It was America's favorite attorney, Ashley Merchant, and the lead attorney is being held in contempt. Well, not the lead attorney, but yes, yes, Brian Steele was held in contempt. Atlanta is really showing their ass. Ridiculous. Definitely true. Who has greater privilege, attorney-client or the courts? The judge believes that the court has a greater privilege of communication than the attorney-client privilege, which is ridiculous.
There's no privilege that the judge has in anything.
He claims that he has a right to basically breach the attorney-client. It's not really attorney-client; it's really attorney-work product. But still, attorney-work product is similar enough to attorney-client that.
What makes this discussion confidential?
Nobody knows. Nobody knows. Love you. Carry on. Let me do a quick check here. Thank you for that. You're too awesome. Let me see. I just want to make sure now I just want to remind you all, first and foremost, in case you're peeking at the numbers, that I am trying to move forward here. If I come back in a couple of days and I see that I had enough views on this thing, whoops, didn't mean to do that.
Look at it go.
Yeah, that is my current subscriber count. I'm marching towards 100,000. We're going onwards.
Dude, look at it go, man. That is really in real time. We're seeing it increase. That's pretty
that is the real time number.
That's amazing. While you're at it, go and subscribe to my channels.
While you're at it, yeah, please. And I mean, the great content that I'm able to provide here is in no small part because of the wonderful guests that I'm able to secure. So if you guys can head on over there and actually subscribe to him, I would be most appreciative of that, because that people come here because they like hanging out with me first and foremost. But the second side benefit is it's nice. It's nice to get a few subs out of it. So if you can all jump on over to Steve Gosney, I'm going to put him in the description here, so it'll be easier for you to find if you're coming after the trial, because we see what value this guy adds. He's amazing.
Well, thank you, and it's great fun being with Anya. I gotta say, every time I'm on your show, or you are on my show, or I'm on your show, I always walk away with just energy and thrilled. So thank you very much for letting me on and comment with you and share this with you.
My pleasure. Barb says now Steele can do his billable hours with his client on weekends in jail.
I'm telling you, that's exactly right. I mean, that's a real cutthroat attorney. Like, I'll sit in jail all day and I'll bill every hour, right?
Well, I think it's an interesting question. Like, let's say can he bill his sleeping hours if he's stuck in prison?
That's a good question.
That's a good question, right?
Yeah,
that's a good question.
Kind of question we need to tackle.
All right. I am going to add Steve. I haven't done it yet, but I am going to add Steve to the description here. In fact, I'm going to do that before I leave here. Let me just, because I don't want to forget.
Yes. Well, I'll put my commercial, stevegosney.com, all of my stuff. I've got.
Yeah, why don't you tell them about your upcoming book?
Well, I've got the one that's available now is called Great Quotes on Law, Faith, and Life. which is I just put this out. That's available now on Amazon and stevegosney.com. And of course, the aquaponics book, Automatic Gardening. They've both been incorporated, though, into the new version of Prepare, which is now 3rd edition, 3.5. So if you can buy these individually for like $10, or you can buy the new version of Prepare, which has both chapters in it. And on the 21st, I'm going to be releasing Death Penalty Designs, Maximum Due Process, which is a masterwork of discussions about the death penalty from a constitutional and legal perspective. So, we have this book, which gives you the public policy debate. And this is understanding the death penalty from a legal and constitutional standpoint, including a summary of the death penalty history, a summary of all the federal case law applying to the death penalty, and then an understanding of the Florida's death penalty statute, and then all of the issues, the reasons that it's unconstitutional. So this will be released on the 21st. It's not ready for publication yet. This is my draft copy. So all stuff is available over there. And I'm not certain. I'll tell you, I just filled out the little form with the state attorney's office. I'm not sure what they're going to allow me to do and what they're not. So I might be zeroed out on everything on the 26th.
Oh.
So I start with the Miami State Attorney's Office in the 26th, and I'm hoping that they'll allow me to continue all things Gosney, but there's no guarantee. So I think I'm going to have a big party on upcoming, maybe Thursday or something. We'll have a big party and we'll celebrate and see how much more I can go.
All right. Link to Steve Gosney is in the description now. So it's even in the title. So you can just click his name in the title, go on over there and subscribe to this fine gentleman over here. I want to remind you all, I'm not going to be streaming tomorrow night. I'm not going to be streaming Wednesday night. You want to know where to find me next? Come to goodlogic.locals.com. It's free to sign up there and get all notifications as to when and where I'll be found. There is a Jewish holiday for the next 2 nights, so I'm not going to be here. So don't go looking for me. Find some other way to amuse yourselves. I will be back, God willing, on Thursday night with my 1,000th upload. The judge also refused to provide the transcript of the ex parte meeting prior to cross-examination. Yeah, this was just an abortion. Digger 67898 here. We come here because our leader demands it. Tuesday is powder blue tracksuit day. Subscribe, you might be digging without a leader. Well, I'm not the leader. I'm just the host. I'm not the leader of the following. I want to thank everyone for participating. I want to thank Steve Gosney first and foremost. Good friend, great attorney. Actually, great friend, equally great attorney, and more importantly, just a really good person. So make sure you sign up to him for his phenomenal content. And I will see you all, God willing, on Thursday. And until then, if you haven't yet, please hit the like and subscribe, follow on Locals, and I will see you all Thursday. Till then, good night. Don't eat the bugs. And Godspeed.